granted bail by Honorable Justice Pujul Kumar Kolita. So this matter may be listed before him, my lord, as per the
Item number?
11, my lord. Item number 11. Co-accused bail has been bench. Yes, and that bench is taking criminal roster, my lord.
That bench is in
Yes, my lord.
Guwahati.
Criminal roster, that bench is taking, my lord.
Learned Counsel Mr. M.H. Chaudhary has submitted that a similar bail petition arising out of the same cause of action has been disposed of by a coordinate bench. Full stop. Ready to place this matter before the appropriate bench.
Friday, my lord, if possible, lordship, on Friday. Kindly, my lord. I'm deeply obliged, lordship.
Maybe, Lordship. So item 29,
Hmm.
I have an interim. As the instruction CD is not there in Lordship.
CDS corporation not received issue reminder list the matter on interim order shall remain in force till then.
Item 9. 29.
May I please, your lordship. Lordship, I beg to mention item number 9, lordship. Lordship, in this matter, CD has submitted, lordship. That's
CD?
the charge sheet, lordship.
Item number 9 shall
Yes.
be submitted.
Item number?
Learned Counsel Mr.
You Ghosh, on behalf of DP Bora, lordship.
No, your name is there. It's okay.
You.
Mr. Yu Ghosh has submitted as it has been late. Full stop heart Mr. P. Bothaku Learned additional PP Assam, who has submitted that Sashit has been late being such CS number.
The CS number 67/25 dated 12/5/25.
Against the petitioner. Full stop petitioner to
For the respondent number 2.
Learned Counsel Mr.
SK Chakma.
SK Chakma
Item number 9.
is present for the respondent number 2. Petitioner is at liberty to approach the jurisdictional court and apply for bail which may be considered by the court in accordance with law.
Obliged, lordship.
May it please your lordship. In item number 25, updated CD was called for. It has not been received, your lordship.
Updated CDS call is not received. We should remind and
25, my
list
lord,
the
PP
matter.
Assam is not a party, my lord.
Huh?
PP Assam is not a party, my lord.
Issue reminder list the matter on.
Oh,
Date sir.
it's been a-
It is submitted by learned additional PP Mr. P. Bothaku.
No, my lord, in this case,
CBL.
PP Assam is not a party.
Act for the petitioner. Interim is there. Interim is there. Obliged.
My lord, regarding CD received or not received, my lord.
PP আছে নি? PP লিখা আছে নি?
No.
নালাগে PP নামটো কাটি দিয়া। Interim order shall remain in force till there.
Yes.
Okay.
May it please your lordship, I beg to mention item number 26 as the engaged counsel is out of station. And interim is there, so
My lord, item number 22 and 23, my lord, tag matter, case CD received.
26.
26.
Learned Counsel Miss
S. Ajmi.
S.
Ajmi. 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 Ajmi.
As me on behalf of
J. Firdaus.
Learned Counsel Mr.
J. Firdaus.
No, but item number 26.
Yes, lordship.
No, J. Firdaus is not
We have filed
representing.
Wakalat Namazest yesterday.
Okay, J. Firdaus has prayed for adjournment.
Yes, sir.
Do you have the CD?
CD not received.
List the matter on. Meanwhile, issue reminder to call for the CD.
Interim
Interim order shall remain in force till then.
obliged.
It's not released.
May it please your lordship, I beg to mention item number 32, my lord. Perhaps CD not received, my lord.
CD as call for is not received. Issue reminder, list the matter on.
Interim is there, my lord.
Interim order shall remain in force till then.
Deeply obliged. My lord, another prayer, my lord, for listing of a BA, my lord.
Senior bench.
My
Deeply,
lord, item number, sorry, my lord, item number 32, search sheet submitted, my lord, in this.
32.
32, yes, ma'am. Right now here.
Your item.
yes, 32, my lord.
Learned Counsel Mr. A. Ahmed is present.
My lord, one prayer, my
What
lord.
is your name?
UU Khan.
Learned Counsel Mr. Yu Khan is present.
My lord,
You want the case to be kept here?
yes, my lord, my lord. Here in this case, my lord, one petitioner's father's name is wrongly listed as another name, my lord.
Then this is AB.
AB,
We cannot keep this case here. You will have to approach the jurisdictional court.
Yes, see. Case number.
Learned additional PP Mr. P. Bothaku has submitted as Sashit has been late against the petitioner being CS number.
74/25 dated 31/5/25.
The petitioner is at liberty to appear before the learned jurisdictional court, stroke Elaka magistrate, and apply for bail which may be considered by the court in accordance with law.
Deeply.
We have the scan copies.
May I please, your lordship?
Grounds of
Lordship,
arrest.
The petitioner is booked under section 21C of the NDPS Act
Hmm.
and is behind the bar for 425 days. And is a 60-year-old aged man. He is behind the bar, and till today, none of the witnesses has been examined. Charge was framed in the month of September 2024, 10th of September 2024, and currently it is 8 months running. None of the witnesses have been examined. If your lordship peruse the order dated 18/1/2024, then it is written.
What is the contraband? Please tell me.
It's morphine.
Morphine.
Yes.
How many kilo?
It's 1 kg, 1.603 grams.
1 kg, 1.603.
1 kg, 603 grams. 1.603.
You don't have the grounds of arrest?
Yes, I have the grounds of arrest, lordship. I'm before this honorable court on the
Grounds of arrest.
on the not conveying the grounds of arrest to the petitioner,
Do
and
you have
also
do you have the copy?
lordship, I have tag marked the in the scan copy the notice under section 50 as well as the arrest memo. Lordship, there is no grounds of arrest mentioned.
Page?
Lordship, it is there in the scan copy. There is a flag mark in it.
You have said you have tagged along with your petition?
I have tagged only the arrest memo, not the 50.
And
Arrest memo and
you're
notice.
relying on which judgment?
Vihan Kumar, lordship, I have annexed the same. I have annexed the same with my additional affidavit. Vihan Kumar, and if your lordship, I can submit this citation along with this.
Yes, please.
Vihan Kumar is there along with my additional affidavit, lordship.
Mhm.
Arrest memo.
You will
is
also submit one judgment now. Now they have a judgment to counter your submission.
Judgment as it.
Yes, you also submit one judgment on grounds of arrest.
Lordship, after Vihan Kumar.
Yes.
Lordship, there is a case pending before the Honorable Supreme Court on the same subject matter, if they are caught red-handed or not. The rash driving case, Lordship is well aware. And in that same case, the Honorable Supreme Court has granted interim bail till disposal of that matter. So I am before this court on the same ground. If the Honorable Supreme Court is on the same ground giving interim till the time the final judgment is not given, that person is on interim bail, I may be given the same privilege, lordship.
Well, otherwise, in this case, yes, in this case, when the petitioner was caught red-handed, my lord, he was traveling as a passenger, and thereupon from his possession, those 1.603 kg of morphine was recovered. In this case, my lord, charge already framed, my lord, matter is fixed for evidence on, my lord, 1/4/25. Next date is fixed on 1/4/25, my lord. And regarding, my lord, the pendency of that case before the Supreme Court, regarding that, my lord,
There's one judgment here that if the case is pending,
Yes.
then I can take up the matter when the case is pending.
pendency cannot be.
According to the precedents,
Yes.
earlier precedents, I can take up the matter and dispose of the matter according to the earlier precedents. So I can take up the matter and dispose the matter according to the earlier precedents. But he will give you another judgment, not the case which is pending in the Supreme Court.
Yes, ma'am.
Lordship, there is another
Not
judgment.
give you, I will say he'll submit another judgment, I mean.
Otherwise, my lord, yes, on the other day, my lord, I already, my lord, produced that judgment of the Supreme Court, my lord, regarding and pointing out.
Can you please,
pointing
give
out
the
those
citation,
paragraphs
he'll
that-
find the judgment for me.
Yes, so
Give the citation.
if someone is caught red-handed, then, my lord, it is presumed that he is already aware of those grounds of arrest. That why, because at that point of time, already grounds of arrest itself is a, my lord, that he is already aware, and, my lord, there is no, my lord, other reasons to serve the
Yes.
person.
Lordship, there is another citation of Honorable Supreme Court recently reported in the year 2024, 3 bench strength. where it has written Jasila Saji, where it has reiterated that even if the grounds of arrest or the in that particular case, what happened, the background of the case was that the person was arrested without conveying the grounds of detention. The person was detained without conveying the grounds of detention to him.
No,
That
but we are not on grounds of detention.
not detention, but that was also
No,
before
but it
this
is not relevant.
grounds of detention. Lordship,
No,
that
no.
comes under
Let's hear
article
him out.
22.
That is not relevant. Article 22 is only information. Article 22, you have to inform. Then, yes, you say something.
Yes, my lord. On that basis, my lord, my prayer before your lordship, my lord. Otherwise, case is already picked for evidence on 1/4/25. Like, case the trial because this is my lord more.
And what is your judgment you are referring to?
It is my lord Madhulimayas at that point of time.
Madhulimaya লিখে দিয়াছোন। Download
Madhulimaya, Lordship, this Madhulimaya and red-handed thing, there is a judgment of the honor coordinate bench, BA number 3043, namely Noor Muhammad, where it has been discussed. Like the Madhulimaya judgment, along with the judgment of the Honorable Supreme Court and Madhulimaya, and this red-handed thing has also been
You
discussed.
give me the judgment.
Lordship, right now I don't have, like, I can provide you the judgments, BA 3043/202. No, Muhammad. No worries. Okay. May I submit this?
Yes, yes.
Red-handed just to be discussed.
একটু suggestion আছে, give us a suggestion to download the judgment.
Yes. Lordship, in this judgment, thank you, sir.
That point was discussed ma'am, regarding 14.
Lordship, in this judgment, this Jasila Saji, it has discussed that even if the grounds are known to the person, but still then serving a copy is mandatory. It is mandatory on the part of the arresting authority, even if they
No,
are.
then we don't have to go. It's in Vihan Kumar, it's in Probate POCSO.
Yes,
We don't
not fair.
have to go to another new judgment. Another judgment of the Supreme Court, I mean. It's already there, which we are discussing in all the cases, POCSO and Vihan Kumar. That there has to be written, it has to be communicated in writing. Okay, I've heard you, then I'll ponder over the matter and I'll pass an order later. All the matters I have clubbed together and
If
then I'll
the
pass an
Lordship
order.
is not convinced on this particular ground, then may I take another date for the same?
Of course, yes.
If your Lordship is not convinced on that particular point, and if your Lordship.
No, I cannot say all those because I'll have to ponder over the matter. I cannot assure you now itself. He has given me a submission and you have given me a judgment.
Yes.
Then I will read the judgments and then I've clubbed, I think, around 5-6 matters together. They have given submissions on Pankaj Bansal and then
Yes.
retrospective effect and
Retrospective effect, Lordship, on that point also, I have a judgment that is Kanik Shah. Kanik's that has discussed that even if that every judgment of the Supreme Court has retrospective.
No. You give me the judgment. Give me the judgment.
Lordship, this it has been made, most probably it has been discussed in here. I'll provide it, Lordship. A date may be given.
All right. Learned Counsel Miss
Albany.
Albany has prayed for adjournment. List the matter on. আধা argument লিখি থোৱা আছে এটা tag কৰি দিবা হা then you come loaded with armed with those judgments.
Lordship.
You want this back? You come, you give it together on that day
Sure.
along with the other judgments. Modulimaya to download করবে ইয়ার ভিতরে ভৰাই দিবা
May it please your lordship. So in item number 32, which you have disposed the case, my lord, as such it submitted, interim may be continued till appearance before the jurisdictional court, ma'am,
item number
as they are the interim.
the last sentence to আগৰখিনি কাটি দিবা. The petitioner is directed to appear before the learned jurisdictional court stroke Elaka magistrate within 20 days and apply for bail which may be considered by the court in accordance with law. To stop till then, no coercive action to be taken.
Interim is there, therefore that.
Yes, till then, no coercive action.
May I please your lordship?
Mm.
This is a charge sheeted case under section 21C and 29 of the NDPS Act for 21.269 gram of heroin. Your Honor, charges have been framed on 24/6/2024. Your Honor, till now, 14 dates were fixed for evidence, but not a single witness has been examined till now. Your Honor, 10 witnesses are present in the case, but not one single witness has been examined. Your Honor, I am before this court on the strength of prolonged detention as well as non-mentioning of the ground of arrest, as well as in the notice under section 50 of the CRPC.
Not a single witness has been examined.
No. Your Honor, I am behind the bar for almost 1 year, 6 months, which is 551 days.
Yes.
Here also, my lord, narcotics were concealed inside secret chamber of the vehicle. These petitioners were, my lord.
He is the petitioner, is the owner of the vehicle. If he is the owner of the vehicle.
No,
then-
Your Honor, I am not the owner.
He is not the owner. He is accused, my lord, caught red-handed, my lord. At that point of time, those, my lord, contrabands were, my lord, concealed inside the secret chamber of the vehicle, my lord, by creating a secret chamber. My lord. Total,
What is the
1
contraband?
kg, 1 kg, my lord,
1.26 gram, 269 gram of heroin.
1 kg heroin?
Yes.
Yes, my lord.
Do you know the value? In 2018, it was 1 crore, 1 kg heroin.
Your Honor, but I am behind the bar for almost 1 year, 6 months, but not a single witness has been examined. 14 dates were already been fixed for evidence.
That this matter may also come up on 29th, my lord, along with item number 1.
Otherwise, I will fix it, reserve it for order. I have clubbed up, I have taken up at least 5 matters. Then if today I'll fix another 5 matters, 10 matters, I'll dispose it.
Your Honor, I can
Together.
file a citation today itself.
Today itself,
Yes.
citations.
Yes.
All right, I'll reserve it for order then. Yes, you submit your citations. You just just give me the details. When was he arrested? When was he arrested?
17/11/2023.
Then how many witnesses have been
10
examined?
witnesses.
Huh?
10
10
witnesses.
witnesses are enlisted in the charge sheet or
Yes.
DRI charge sheet?
Charge sheet.
Not a single witness has been
No.
examined.
Charge frame.
14 days were fixed. 14 dates were fixed for evidence. It's for evidence.
14 dates fixed for evidence.
Yes, Your Lordship.
Charge frame on 24/6/20.
Charges framed on 24/6/24.
So this, what is the contraband heroin? 1 point, how many grams? 1 kg?
1.269 grams.
1.69 gram.
1 kg, 1.69 grams.
Grams.
Okay, 1 kg, 69 grams. Okay.
Yes.
You want to submit a
Yes, Your
authority,
Lord.
any authority?
Yes.
Then you will stick to Madhulimai.
Otherwise, my lord, some other grounds I will have to point out to your lordship. Madhulimaya's death paragraph already I pointed out, my lord, regarding discussion about that, my lord, caught red-handed, my lord. These already known.
Anything else?
Yes, my lord, on that basis, my lord. Already aware of that grounds of arrest, my lord.
Can you reserve for
He is not entitled.
Order of
to
conduct?
any-
One day I'll pass the orders of all those cases. 5 cases are with me, and today I think I'll get another 5 cases. In one single day, I'll pass the orders.
I can pay.
My lord, the present case related to POCSO, my lord. Charge sheet already filed.
So I was thinking another case of NDPS, so I was thinking of writing notice.
Really.
Let him obtain instructions.
Kindly pass over the matter for the timing. CDs coming.
Much obliged.
My pleasure, Lordship.
Yes.
Lordship, I prefer this bail application on two counts, my lord. Basically, the prolonged incarnation. The petitioners are behind the bar for last 2 years, 5 months and 21 days. And as on date, my lord, only 2 witnesses have been examined in the case. And the second is that, my lord, the section non-compliance of section 50A and non-compliance of section 50 as per mandate of the law, my lord.
How many years you are behind bars?
2 years, 5 months and 21 days, my lord, as on today.
How many witnesses have been examined
2 witnesses have been examined, my lord,
out of?
out of 8 witnesses.
This is an objection.
My lord,
We are yet to receive the copy of the objection, my lord.
my lord, we have filed an objection, but we could not file it in the court because it was not as per the format of the court. So today, I just handed over the objection here.
You'll have to file it before the registry.
My lord, but that is not in the proper format, so I could not file it. So for that, I have to take some time, my lord. I may
Let
file-
it, give him some time to file the objection
Lordship,
properly.
Lordship. And we have not also received the copy of the
Okay. Learned counsel, Mr.
PDAS, Lordship.
PDAS is present for the petitioner. Learned counsel, Mr.
MK Bodo, my lord.
MK Bori is present for DRI.
DRI, my lord.
DRI and has submitted. You are standing counsel?
Standing counsel.
Learned standing counsel, Mr. MK Boro is present for DRI and has submitted for time to file his objection. List the matter on. When do you want?
The last part of this month, my lord,
Last part of this month, yes.
30.
You'll be able to file within 30 May.
My lord,
This is already, it is ready.
this area, my lord, just it should be in the
Okay.
proper format, my lord.
Okay,
Uh,
30 May.
My lord, can it be on the 1st of June, my lord?
Can be, can
Oh,
be,
the second.
can be.
Second.
Second.
Highly obliged.
Obliged.
Better maybe pass over for the timing.
All
The last time I had not taken step videos, the last occasion, so I have taken steps of the lordship.
today,
No, on the 8th of this month. Your Lordship.
okay. Service of notice,
Yes,
respond number
yes,
two.
he was an order of this honorable court.
Service report on respondent number 2 is awaited. List the matter on 4th June. We have the scan copies.
Obliged, your lordship.
Item 12.
What is the lordship? Today was 6 for the lower court report, your lordship.
Hmm?
Lower court report. The bail application, your
Hmm.
lordship.
Hmm.
Against the arrest and detention of the accused Rajandas, who was arrested in connection with Karimganj Sribhumi PS case number 680/2024 under section 6 of the POCSO Act.
Hmm.
The accused was arrested on January 2025. And since then, he's in bail.
January
he's in bail.
2025.
Yes, your lordship.
24.
January 2025.
But you have written 15/1/2024.
15/1. 15/1/2025 in para number 10, your lordship.
No, but you see, page number 3 on the top. It's 15/1/2024.
15. Let's see that. The 15th, it may be typographical error, 15/1/2025, it's the correct. Check.
All right.
If the case is under trial, since there is arrest, the petitioner is behind the bar, your lordship. So the matter may be considered
Yes.
Grounds of arrest, Lordship. And Lordship, this.
How many cases you have? Let us club those together and we'll hear you out finally on grounds of arrest. How many cases today?
Today, this is the last
Last
one
case.
we had. Lordship, the Madhulimaya judgment that has been stated by the RPP sir. Lordship, what my little understanding says that in that Madhulimaya judgment, although the red-handed thing has been discussed, still then the Honorable Supreme Court was pleased to grant bail.
Interim
on-
bill.
Yes, on the ground bail, considering that the grounds were not conveyed to that person. And accordingly, these judgments were submitted in the
Do you have
coordinate.
the order of the interim bill of the Honorable Supreme?
Yes, I have the order. I will submit it today itself, and this order may be reserved on the grounds of on the part of grounds of arrest, and in the coordinate bench, Lordship. Same this Madhulimaya judgment along with some Ram Arora case and Om Prakash Trivedi. These are the prosecution friendly judgments submitted by the PP sir. Although considering all this citation and on basis on the after hearing both sides, the Honorable Court was pleased to grant bail in this Noor Muhammad case. I will submit that also, Lordship. And today, along with this, is the same may be reserved, Lordship.
Yeah.
I will
You give me
submit
the,
the
you give me the details
yes.
when he was
Lordship,
arrested, what is
under
the
section
contraband?
Yes, under section 21C and 29, there are two person. I am for 2 person, and arrested on 20/10/2024, and as of today, it is 210 days.
How many witnesses are enlisted?
17 number of witnesses, none of them examined till date. And in the arrest memo, these columns are kept blank where the grounds of arrest has to be written. These are all kept blank in the arrest memo. I have annexed it with my petition.
Page number?
Lordship, page number 30 of my additional affidavit. Lordship, in the additional affidavit, page number 30, there is column number 5, where it is written relative or friend at the time of the arrest, where there is no name mentioned as to whom the said information was conveyed. And there again in column number 8, signature of witnesses is there. There is no signature of witnesses in the arrest memo. So considering these aspects, Lordship, any condition may be.
Otherwise, your lordship may fix along with other matters on 29th on that day, my lord.
On 29.
29th, to other matter.
I have to have. I did to
Earlier
it
matter
may be reserved.
And what do you want to say?
Otherwise, on that point, I will also make some argument, like if your lordship may be pleased to fix on 29th.
Okay, then let us give him some time.
There is
To place his argument.
29. There is already one matter there. We'll argue.
No,
on
Your
that.
lordship will fix.
29 today's what's today's 20th?
21.
9 days, okay. Okay. Can you make it earlier in this case at least?
Already that matter was fixed on same issue, my on 29th.
This may
No,
be.
but that time she asked for
Yes, on 20. Wow,
Maybe
today's 20th, no?
21.
20.
Yes.
21st.
On 27.
8 days. 27?
27.
27, okay? 27. Let us also give him some time. Okay. What is the contraband, by the way?
Morphine. Morphine, it is 608 grams. 250 grams is the commercial quantity.
Learned Counsel Ms. L. Bonigma is present for the petitioner. Learned additional PP Mr. P. Bothagur has submitted for time to place his objection. Place the matter on apex.
Item 14.
May it please your lordship.
Yes, yes.
My lord, arrested on 18/3/25. And till today, my lord, 60 days in custody.
Arrested on
18/3.
18/3/25.
Yes, my lord.
60
And
days.
yes, case registered under 376 and 67A of IT Act. FIR is at page. FIR is at page.
Lordship, 355 days, around a year, Lordship. And Lordship, initially the FIR was registered under section Lordship
31/5/2024.
24, 355 days.
55 days. POSCO?
POCSO lordship.
এইখিনি অফাৰ ৰাখিব অলপ দেৰি চব POSCO মেটাৰ দিব নেকি এতিয়া
May I please your lordship? Your lordship is a bail application engaged in NDPS matter, your lordship, commercial quantity. The FIR is at page number 11, your lordship.
okay how many days you are behind bars
Your lordship, I am behind the bars for 1 year, 1 month and 23 days. Until date, not even one single witness have been examined, your lordship.
1 year 1
1
month
month, 23 days, your lordship.
23 days no witness examined
No witness examined, your lordship.
how many witnesses are enlisted
Your lordship, 7 witnesses have been enlisted, your lordship.
what is the contraband
Contraband, your lordship, is 6,400 yaba tablets, which is around 584 grams, your lordship. Little more than commercial.
6,100 yaba tablets
Indeed, your lordship.
500 yeah?
84 grams, your lordship.
54 grams of arrest
Indeed, your lordship. But before that, I also have a small submission, your lordship.
Oh.
Your lordship, if your lordship may come to page number, annexure number 3, page number 15, your lordship, you will find that this is the higher secondary school admit card of the child, your lordship. Both the boys were merely 23 years old, your lordship. And now his admission in the further course of education is pending, your lordship. Just after his higher secondary examination, he has been picked up. I'll come to the ground of arrest at the later stage, your lordship. The boy is merely 23 years old and his education is at
higher
flight
secondary 23 years
in his
18 years 5 years plus what is doing
your lordship, village school, your lordship. They take admission late, and again, he is a completely rural area, your lordship. Your lordship, this is the contention that the seized items were recovered from the person who was riding the motorcycle and from his bag who was riding the motorcycle, your lordship. I was merely sitting on the back seat as a pillion rider.
both the boys are picked up after higher secondary examination
Your
both
lordship.
the petitioner
I'm not submitting for the other accused person. Only one petitioner who is the pillion. He has been picked up after his higher secondary examination, your lordship. And he was sitting on the back side.
he is the pillion rider
He is the pillion rider. Nothing was recovered from him. The recovery happened from the rider who is the owner of the bike, and
what
also
charge sheet has been submitted again
that sheet has been submitted against both, your lordship. And
Okay.
From the bag of the rider, your lordship. This is the entire facts of the case, your lordship.
okay
Your
and then grounds of arrest
Indeed, your lordship. In the grounds of arrest, your lordship, I have a small submission to make, your lordship. With regards to the case, your lordship, of Jasila Saji versus Union of India, as decided in September 2024, your lordship. Your lordship, if you look into paragraph 19 of the said judgment, your lordship,
you know
citation is, your lordship, Jasila Saji versus Union of India.
you will give me the judgment
Yes, your lordship, I'll give the judgment. Criminal appeal number 3083 of
you do
2024.
not
your
give the Supreme Court citation 2024
Supreme Court citation, your lordship. A criminal appeal from the Supreme Court direct website of the Supreme Court, your lordship.
no
SCC,
you give me the citation SCC citation
SCC.
because this is a judgment of
In-
2024 we'll have the citation if it's a reportable judgment
Indeed, just a moment, I'll give the citation, your lordship. Your lordship, the citation is,
later
your
it's
lordship,
okay.
2024 9 SCC 53, your lordship. Jaslila Saji versus Union of India,
9 SCC
SCC 53, your lordship. 2020-24 9 SCC 53. Your lordship, in this said judgment, your lordship, if you come to paragraph number 19 of the said judgment, your lordship, I'd just like to read it out for the court, your lordship. Your lordship, just
so many have read this out
one contention is that with regards to the object of red-handed, your lordship, my humble submission would be that here in the said judgment, in the said paragraph, it has been clearly mentioned that as practicable by the investigating agency, there is a difference between arrest memo and section 50 notice. The judgment clearly says that at the time of arrest, to his near friend or to the person concerned, you are submitting the arrest memo. Thereafter, before production, before the magistrate, you have enough 24 hours to give him the arrest memo with the ground of arrest. Because in this instant case, the person who is behind the bike is a pillion
give me
rider.
the submission why do you have to explain I'll read it
Indeed,
because everybody has explained it to me so many times
your lordship, that is our same contention that we were not aware of what the substance the other person is carrying, and neither we are given the grounds of arrest. Moreover, your lordship, with regards to the arrest memo and the ground of arrest, I have both the documents I would like to pass on to the court, your lordship.
we have the LCR also
Scan copy, sir.
yeah you give it to me it'll be easier for me
Our both the grounds are in a large scale of incarceration, your lordship. 1 year
Citation, give it to me
citation.
not citation you have the judgment
Yes, I don't have a printed copy, your lordship. I'll get a printed copy and
it's
submit
okay
it.
I'll get it out
Another
Yeah,
case, your lordship.
give her the citation she'll get it out
Your Lordship, another
Please,
case,
Give
very,
her the citation. Give her.
very recently also on 30th March, Your Lordship, 30 March 2025, the again Supreme Court in Ashish Kakkar versus Union Territory of Chandigarh discussed the same thing, Your Lordship, on 30 March.
That you'll have to give it to me.
Indeed, I'll submit the citation, Your Lordship. Citations are there. 166.
166.
All right.
Indeed, Your Lordship. This is the Lordship.
Apni copy. DP.
My lord, otherwise, my lord, the judgment put it by my learned pen, my lord, I will have to go through these judgments. My lord.
Okay. Let us give him some time.
Indeed.
Hard learned counsel, Mr.
T. Laskar, Your Lordship.
T. Laskar for the petitioner and learned additional PP, Mr. P. Botagu for the respondent state, comma, full stop. The learned additional PP has submitted for time to go through the judgments submitted by the petitioner. List the matter on
My lord, 3rd of June.
3rd of June, or you want it earlier?
At 1 year, 1 month, 23 days, Your Lordship. Long interval. Not even one single
What is the
witness.
contraband, by the way, Yaba tablet?
Yaba tablet 584 grams, Your Lord.
Only.
Only. Much obliged.
It is sorry, Vaha.
Please, Your Lordship.
Manas later? Okay.
May I please, Your Lordship?
Yes.
Your Lordship, this is a matter against the NCB, commercial quantity of narcotics psychotropic drugs, Your Lordship. FIR is, complaint is at page number 10, Your Lordship. Your Lordship, in the instant matter,
What is the contraband?
Your Lordship, 335 grams of heroin, Your Lordship. Did not recovered from my possession, Your Lordship.
How many days you are behind bars?
Your Lordship, I'm behind the bars for more than 3 months, Your Lordship.
This investigation is going.
64 days, Your Lordship.
Huh?
Investigation is going on.
Oh, you have the CD, no?
Yes, Lordship, I have CD and all the procedure has been followed. And Lordship, he is the kingpin, he is the main supplier of the narcotic, Lordship, that has been come during the investigation.
Your Lordship, may I submit, Your Lordship? Your Lordship, in this instant matter, a woman was arrested in Guwahati railway station.
You are behind bars for how many days?
For Your Lordship, 60.
25, 1, 20, 25.
64 plus 90 plus.
25, 1.
Probably 112 days it's completed.
120.
Okay.
116 days.
25, 1, 25.
Indeed.
116.
116 days to go.
116 days, okay.
Your Lordship, a lady was arrested in Guwahati railway station, Your Lordship, with 335 grams of heroin, Your Lordship. Thereafter, based on her 67 statement, when she has disclosed that the accused petitioner in the instant matter has supplied her so-and-so drugs, Your Lordship. Thereafter, I was called at Agartala unit of NCB, Your Lordship. And in the Agartala unit of NCB, Your Lordship, I was given a ready-made statement already printed, Your Lordship, and asked to sign. Your Lordship, in page number 18, it is mentioned in our petition, Your Lordship, that when I was taken to the Agartala NCB unit.
Why they are so interested to give you one bigger statement to sign?
Indeed, Your Lordship. Therefore, I denied to sign in that statement, Your Lordship. It is mentioned in the forwarding also that when I was served with a 67 notice and then my statement was recorded as per the record, I denied to sign in this statement, Your Lordship. Thereafter, Your Lordship, in Agartala, they have given me the grounds of arrest, Your Lordship. They have given me the section 15 notice, Your Lordship. Therefore, neither I was present in the entire state at that point of time when this entire incident occurred. Based on a 67 statement, which
That
is,
you know, na? Tufan Singh's judgment.
indeed,
is
Tufan
not
Singh judgment
required to
applies
be
here
followed
also, Your Lordship. After
during
the
investigation.
Indeed, Your Lordship. After the Tufan Singh judgment, I was not informed the ground of arrest, and this is not a case of red-handed pickup. I was in some other airport, Your Lordship. From there, they have taken me for investigation, asking me questions, and thereafter, without furnishing the
This
ground of
story
arrest,
will not work.
I have taken, I
This
mean, under
story will
custody,
not
Your
work.
Lordship. And the There is my direct violation of my constitutional right, your lordship.
What?
Without serving the ground of arrest, your lordship.
No,
And
it
not,
has been served.
not,
according
I
to
have a
that.
copy of the
Yes,
ground of arrest.
Lordship, he is, Lordship may please to see.
According to them, grounds of arrest have been served, copy has been served
I
to you.
have submitted an additional affidavit, your lordship, with the
And Lordship, I want to, Lordship, the statement of that lady along with the present petitioner is there in the record also.
Lordship, this is the certified
And
copy
he
of
was intercepted in Agartala airport, Lordship.
I'll read it out to you. You are hereby informed that you are arrested in connection with the above reference case in violation of NDPS Act, so and so, with seizure of 335 grams of heroin. What do you want? You want a story?
your lordship, in Prabir Purkasa judgment, paragraph number 49.
I
It has been
335 grams of heroin recovered from a possession. Everything is mentioned in the grounds and he's given his signature in English.
indeed, your lordship. There
Then
is,
what else do you want?
our thin line of submission is with regards to reason of arrest, your lordship, and ground of arrest. your
Reason of
lordship.
arrest is given.
Reason of arrest is given, your lordship. Ground of arrest is not given in this.
Grounds of arrest is also given.
Your lordship,
I'm rejecting it.
indeed, your lordship. Because your lordship, paragraph 49 of the judgment clearly says the ground of arrest has to mention the
Everything is given here.
story in elaborate, your lordship. Here only
47
reason is
here,
mentioned.
double S.
Your lordship, only reason has been mentioned here, your lordship. There is no mention of the ground, your lordship. Not even one brief fact from whom the contraband has been recovered, your lordship. That does not constitute as a ground of arrest.
You want to give me that judgment, that reasons and that paragraph 48 of.
49 of the
Prabir
Prabir
Purkasa.
Purkasa judgment. That reason of arrest has been given, not ground of arrest, your lordship.
I'm rejecting it. I'll just memorandum of arrest also. There's a memo of arrest.
Yes, Lordship, it is there. Lordship, below Lordship, interestingly, Lordship may please to see.
Below where?
Below of the memorandum of
where?
arrest, Lordship, yes, Lordship.
They're written in
There is-
handwriting.
No, it was,
Handwriting.
it was written by the officer. He refused to,
Oh,
and Lordship, some other documents are there.
oh, yes. Deposit did not return to, refuse to sign.
Yes.
Your lordship, this is the same story. When I'm already given a printed statement under section 67 just to sign, your lordship, then the person
And Lordship,
denied to sign.
the documents are there. I'll point out. Lordship. And his statement is here, Lordship. How about Lordship, investigation?
He's given his confessional statement also.
Yes, Lordship.
That is, we have denied to sign that statement, your lordship. It is clearly mentioned that the deposit does not denied to sign.
That
the
is there, that was signed by him.
Oh, that 161 statement is required to be signed.
Indeed, your lordship. Under section 67, no, not quite to be signed. It is 161, your lordship. We're talking about the 67 NDPS.
You are only on the grounds of arrest. No?
My limited prayer is, your lordship, with regards to section paragraph number 49 of the Prabir Purkasa judgment, that this is the reason of arrest and not the ground of arrest, your lordship. My limited submission, your lordship.
According to me, my interpretation, this is the grounds of arrest as well as the reasons of arrest.
Your lordship. My limited submission, your lordship.
Now everybody will give you the grounds of arrest.
Indeed, your lordship.
You don't explore for all these grounds of arrest, reasons of arrest now.
Your lordship, if I just read the last line, which says that the grounds of arrest informed in writing must convey to the arrested accused all basic facts, your lordship, all basic facts on which he has been arrested, so as to provide him an opportunity of defending
Did
himself.
you get? Let me see your copy. Something different from this CD or similar to this CD.
Similar to the CD.
Similar to the city. All details are there. Lordship.
Case is non-bailable. You'll be produced before a session judge. You may submit petition for bail. In connection with seizure of 335 grams of heroin.
Indeed.
Same. I thought you got a different copy. The way you are submitting. Any document you want to rely on?
Your Lordship, we will just keep our submission very limited
Grounds
to
of arrest.
49 grounds of arrest. And also that I was picked up in Agartala, and then the statement which was given to me under section 67 was not signed by me. Your Lordship. I did not sign that document. Your Lordship.
Yes, you. What do you want to say? What do you want to say?
First, Lordship, my first submission, all the requirement of 47 and Article 22 has been complied with.
47, eh?
47 of BNSS.
Mm.
Then Lordship, investigation is going on. Lordship, we are collecting materials against the petitioner. There are sufficient materials available in the case record. And he is the kingpin who supplied the drugs to the arrested accused.
The lady.
Yes, Lordship. That's he admitted, and he himself admitted, Lord.
Please give me the judgment of POCSO section 40 paragraph 49 or way.
Paragraph 49, Your Lordship.
Judgment.
I'll submit a printed copy, Your Lordship.
No, I want to dictate it now itself.
Your Lordship, please.
I don't want to take the burden of this CD because I already have so many scanned copies with me. Have you annexed this with the petition?
Additional affidavit annexed.
Additional affidavit there.
So why are you in such a hurry? You want to go to the Supreme Court after this rejection order?
Yeah.
Why are you in such a hurry
Your Lordship,
at this stage?
I'd just like to mention one more thing, that Your Lordship, Article 22 connotes a negative right on the state, Your Lordship. It's not a positive right on the state. And therefore, the wording of Article 22 says protection against arrest and detention, Your Lordship. And therefore, it's a negative connotation on the state, for which the state has to be more careful while issuing the notice, Your Lordship. It's not a positive right on the state, Your Lordship. And therefore, these grounds becomes very essential, Your Lordship. If not from conscious possession, Your Lordship.
But learned counsel, Mr.
T. Losco, Your Lordship.
D. Losco for the petition. T. Losco for the petitioner. Deposit Devnath. Elias Osade, who has filed this application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 24/1/2025 in connection with NCB Guwahati crime number 1 of 2025, registered under sections 8C, read with section 21C and 29 of the NDPS Act 1985. Heard Mr. S.C. Kayal, learned standing counsel for NCB. It is submitted on behalf of the petitioner that the petitioner is behind bars for 116 days and his right to personal liberty has been curtailed as the grounds of arrest has not been communicated to him. The annexure Annexure A of the additional affidavit submitted by the petitioner relating to the grounds of arrest reveals that the reasons of arrest has been mentioned to the petitioner while the grounds of arrest were not mentioned to the petitioner in a manner understood by the petitioner. The petitioner has relied on the decision of the Honorable Supreme Court in Procedural POCSO versus so-and-so, paragraph 48,
49, Your Lord.
49. It is further submitted on behalf of the petitioner that the petitioner has been forwarded to custody solely on the basis of the statement of a co-accused who was initially arrested while in possession of 335 grams of heroin. First off, it is submitted that the NCB tried to force the petitioner into affixing his signature on his confessional statement under section 67 of the
NDPS.
NDPS Act. And this is the reason why the petitioner did not affix his signature on his statement. On the contrary, the learned standing counsel has submitted that the petitioner has given his signature
Yes, Dr.
on the
Yes.
statement. It is also submitted that there are incriminating materials in the case diary against the petitioner, who is the kingpin, supplying drugs to the kingpin supplying drugs to the arrested co-accused. What is her name? Bhattacharya, what?
Rudrani Bhattacharya.
Huh?
Rudrani Bhattacharya.
Rudrani
Bhattacharya.
Bhattacharya, who was caught red-handed while transporting 335 grams of heroin. I have scrutinized this is the case diary, or what
Yes,
it
sir.
is called? Offense report.
The case diary.
Case diary. I have scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioner. The grounds of arrest marked as Annexure A clearly reveals, or the notice under Liquidia. The notice under section 47 of the BNSS clearly reveals that the grounds of arrest have been communicated to the petitioner. The reasons as well as the grounds of arrest has been communicated. The petitioner was clearly informed that he was arrested in connection with NCB case number 1 of 2025 under section 8C within bracket small c, read with section 21 capital C within bracket and 29 of the NDPS 1985. He was also clearly informed that he was arrested in connection with transportation of 335 grams of heroin, and the case is non-bailable, and he will be produced before the trial court, and he may submit his petition with prayer for bail. If the entire notice under section 47 is scrutinized, it clearly reveals that there is no violation of article
22.
22(1) of the Constitution of India. It is the petitioner's right to personal liberty has not been curtailed. The petitioner who has received the notice has affixed his signature in English. It can be correctly interpreted that the grounds of arrest vis-a-vis the reasons of arrest has been communicated to the petitioner in a language understood by the petitioner. The petitioner's plea for bail on non-communication of the grounds of arrest can be safely dismissed.
Much also.
In view of my 248 to लिखित हुआ paragraph 4. In view of my foregoing discussions, the petition stands rejected at this stage.
Much obliged.
Send back the CD.
May I please, your Lordship? Lordship, NDPS case, I am behind the bias for 612 days, my lord. That is 1 year, 8 months and 4 days. My lord, the charge sheet was filed on 29th to 2024 at page 27 of my petition, my lord.
When was the charge sheet filed?
A charge sheet on 29 to 2024, my lord. Out of 9 witnesses till date, only 3 have been examined, my lord. I am on the ground of, my lord, prolonged detention and snail pace of trial, my lord. In this regard, I'd like to refer a judgment of the coordinate bench of this honorable court, my lord.
You were arrested on?
16/9/2023. 612 days. I'm a driver and handyman of a truck, my lord. The truck was also, the Zimma of the truck was also given to the owner.
You are driver and handyman.
My lord,
Two
two petitions.
What were you submitting last sentence?
My lord, prolonged detention and snail pace of trial, my lord. And in this regard, I would like to refer a coordinate bench judgment, my lord, of this honorable court.
You are not taking the plea of grounds of arrest?
My lord, it is there,
Taking-
the third ground, my lord. Grounds of arrest. I have flag marked it in
What
the,
is the contraband?
my lord, 215 cartons of codeine-based cough syrup, my lord. My lord, I am the driver and the handyman. What is inside the cartoons, my lord? I had no idea about this.
Okay.
Let me refer para 16 of the judgment, my lord. Judgment of this coordinate bench. May I read?
Hmm.
There is another aspect of the matter which deserves consideration at this stage. The allegation in the present case relates to an accused being involved in a FIR relating to commercial quantity of contraband under the Act of 1985. While considering a bail petition in a case involving commercial quantity, the court has to keep in mind the rigorous enumerated under Section 37 of the Act of 1985, which mandate that the court can grant bail to an accused only after hearing the public prosecutor and after having satisfied itself of the twin conditions which are reasonable grounds for believing that the accused is not guilty of the offence charged, alleged, and that he is not likely to commit any offence while on bail. The stringent rigors of Section 37 of the Act must be meticulously scrutinized against the backdrop of the accused's fundamental rights to speedy trial. The right to life and personal liberty cannot be rendered nugatory for unwarranted delays in the judicial process, particularly when such delays is neither attributable to
Okay.
malice. Otherwise, my lord, in this case, date of arrest is on 16/9/23. Date of arrest is, my lord, 16/9/23. So, my lord, on that point, my argument.
Date of arrest is 69/23, yes.
Yeah. My lord, before 3/10/23, that is before consequential judgment. So, my lord, regarding grounds of arrest, my argument before your lordship that he is not entitled to claim benefit on that ground, my lord. My lord, Article 22(1). And otherwise, my lord, long incarceration, my lord, today is, my lord, only 1 year, 8 months, my lord. He was arrested on 16/9/23. And my lord, thereafter, charge sheet submitted on 29/2/24, my lord. And my lord, there is. Till date, my lord, only 3 witnesses have been examined. Arun Kumar and many other decisions also, your lordship, earlier I pointed out, my lord, that grounds of long incarceration also, he is not entitled to get bail in this case.
I'll reserve it for judgment.
My lord. Deeply obliged.
Item 18 may pay for, it may be taken about some other day.
Item 18.
18.
All right.
Otherwise, perhaps CD is there.
CD receipt, my lord.
CD.
Yes.
Okay.
I
Oh,
want to take some
only
ground,
two
my
will
lord,
be-
because the extension of time of under Section 167, that has not been followed, my lord.
Only for 1 week will retain the CD.
1 week, my lord, that may be fixed.
Liquor of item 18. Learned counsel Mitra,
He has a regard.
his Hazarika has prayed for adjournment. CD is received, CD to be retained till one the date of the media. Or 28 date.
28 May. Obliged.
May it please your lordship. Lordship, regular bail application, my lord. Petitioner is behind the bars since 14/4/25, my lord.
You
That
have the CD?
that will be
Yes,
38
yes.
days, my lord.
Where is the FI?
FIR at page 12, my lord. May I read, my lord?
Yes, yes.
With due respect, I, Dr. Pallab Kumar Sharma, so and so, would like to bring to your kind notice that self has recently got victimized on financial fraud and lost an amount of rupees 25 lakhs. The incident started on 21st February 25 at around 10:30 a.m. Through a mobile call, the person introduced himself from telecom department and connected to Delhi police to clarify on FIR against me on 14/8/24 related to one mobile number used on my name. The person to whom I got connected showed his iCard on video call as Inspector Gopesh Kumar from Delhi Police, took my statement and simultaneously shared some documents regarding some money laundering case. All documents enclosed for your perusal. The person kept me under constant surveillance through WhatsApp video call for almost 48 hours and finally advised me to deposit the amount mentioned above and also shared the documents that this amount will be returned by the RBI within 48 to 72 hours of verification. So-called Gopesh Kumar remained in touch till 11 March 25 and kept assuring me on getting the amount back. Later on, when he stopped receiving my calls, then only I have realized that self got victimized to a financial fraud. The person used 3 phone numbers to contact so and so, so and so. The amount was transferred in my from my HDFC bank account number. 2 account has been given, my lord.
Yes.
Lordship, the petitioner is no way not even mentioned in the FIR, my lord. He was arrested merely on the ground of suspicion, my lord, and no notice was served upon him under section 35(3), my lord. My lord, he is a plumber, my lord, by profession, working under a contractor at Guwahati, my lord.
What do we have?
Otherwise, my lord, regarding notice, my lord, all procedures were followed, my lord, notice served, my lord. And regarding these are, my lord, your lordship may kindly peruse his statement, my lord. I just. Otherwise, my lord, these are serious offenses. This type of offenses, my lord, continuously going on. How by introducing themselves as a, my lord, member of some investigating agency, my lord, how this. But regarding the involvement of the present petitioner, one of the SIM that is specifically mentioned in the FIR that belongs to in the name of the present petitioner, and in his statement, present petitioner stated that he has, my lord, already regarding that he has lost one FIR, but there is no such, my lord.
That is for the informant, my lord. These 2 account numbers belongs to some the petitioner. The phone numbers given, my lord, are not mine, my lord.
Yes,
So how-
is my lord 9678661709 is of the present petitioner. My lord.
No, my lord. The police has not seized anything from me, my lord. And
That is my lord in 9678661709. That is my lord. Investigation is going. The FIR disobey
someone named Gopesh Kumar. No, Gopesh Kumar.
Gopesh Kumar to and amount.
There are materials.
Lordship,
But
may I
do you
submit,
want
my lord?
behind bars? There are
Yeah, there
materials.
are only difficulties that, my lord, in his one of the phone number, which is specifically mentioned.
No, there are analogous connecting phone numbers.
Yes,
Earlier it was closed.
yes.
So this is his phone number.
But there, regarding that, he has not lost.
This phone number has been connected with the other numbers
Yes.
of this.
May I, lordship?
Lordship, this person introduced himself as Gopesh Kumar, my lord. So, my lord,
Introduced as Gopesh Kumar, but by using.
these are, my lord, cyber criminals, my lord. I have no knowledge, my
He
lord.
has been identified.
But, my
He has
lord,
been identified by the complainant because he made a video call. According to the FIR, he made a video call.
Lordship, no, my lord. Someone named Gopesh Kumar, he is involved, my lord. I am not there, my lord. I am a plumber, my lord. I have no knowledge about.
I won't disclose the
cybercrime.
materials. There are materials against him. But I'm just asking him, do you want him behind bars?
Lordship, 38 days, my lord, already behind bars, my lord. And my lord, during his production also, police has not sought any custody, my lord, police custody.
Let them
So, my lord,
fix next week. I'll get the instruction, my lord, regarding, my lord, about the stage of investigation and specifically regarding the involvement of the present petitioner. Because there are identification parodies also there, my lord. Video from that, my lord, his mobile number also was also used, that is specifically mentioned in the FIR. But regarding, my lord, further custodial interrogation, my lord, from the because, my lord, some of the investigation is yet to be, my lord, some of the still, my lord, going on. Some of the documents, my lord, regarding those involvement of the other persons, my lord, still one another person was also arrested. One, my lord, other accused persons was also arrested.
So now you cannot do custodial interrogation. He's in
Yes,
judicial
but
custody.
sorry, my lord, regarding further, my lord, I will just only to get the instruction, my lord. Already materials is there. From that point of view, my lord, it is difficult for me to say whether further custodial interrogation of the petitioner is necessary or not.
but police has not sought any police custody, my lord.
No, custody, not that custody. In
Police-
jail also he should be
Yes, yes.
interrogated.
Yes, he may be interrogated if required in judicial, while in judicial custody also. Because some of the information not yet.
Those who have, my lord, identified, those who have made video calls, my lord, they are already cyber criminals, my lord, and I am a plumber, my
He has
lord.
been identified
Yes.
by the complainant. Pointed out, he is the one.
Let him take
His
instructions.
photograph
and-
was taken. Okay, then you can obtain instruction.
Yes, I will.
Learned additional PP, Mr. P. Bothagur has submitted that he may obtain instructions relating
no.
to the
Fix it some other day, my lord.
instruct.
Not for any instruction.
Prayed for time लिखिए. Prayed for time instruction था लगा. Prayed for time. CD to be retained till 1 week.
Yes.
Release the matter on 28 May. CD to be
5th
retained
of
till
June, my lord, 28.
5th of June, okay.
5th of June.
5th of June लगे पाई नहीं किसी retain को बोले. Cannot. This is a cybercrime investigation.
Yes,
We
my lord,
cannot
yes,
retain.
yes.
28 May.
Deeply obliged.
Section 13 and 14 of Assam Game and Betting Act, Lordship. Lordship, petitioner number
In
one
this
is
case, the
behind the
charge sheet
bar of
submitted, my lord. Charge sheet submitted.
Charge sheet submitted, you approach the jurisdictional court. Our learned counsel, Mr. J. Akhtar,
M. Khan.
M. Khan for the petitioner, and learned additional PP, Mr. P. Bothakur for the respondent state, who has submitted that charge sheet has been laid against the petitioner being CS number.
My lord, CS number 48/25, dated 12/5/25.
The petitioner is at liberty to approach the jurisdictional court and apply for bail which may be considered by the court in accordance with law.
Item 21.
Please, Your Lordship, the matter relates to Assam Game and Betting Lordship, the allegation regarding online betting Lordship. There are 22 days behind the bar, everything has been seized from their room Lordship, the computer, laptops, mobile phone, SIM card, everything has been seized Lordship. Further custodial detention might not be required Lordship.
This is FIR at page 11.
Lordship.
Our learned counsel.
Lordship, may I please, Lordship? Hearing this, we have received the CDs. Lordship,
You want him behind bars?
Lordship, because Lordship,
Why?
all those persons are from Bihar, Lordship, not from Assam, Lordship. And they are during interrogation, lordship, they did not disclose their even the password of that laptop, lordship. They are on whatever there is, lordship. Even they did not disclose it, lordship. And now they have given their bank statement, lordship, because it's an organized crime, lordship. Because they are not there doing, lordship. They are doing that IPL business, lordship. IPL game making business, lordship. And the entire locality is involved in this way, lordship.
But you
And
see, how long will take for investigation? 30/04/2025.
lordship, only
Mainly
24 days to be.
regarding Assam
Police,
Government
there are some
Meeting Act, lordship.
during this period, lordship, Panchayat election has also passed, lordship. There are police is not only because behind him, lordship. There are some other cases are also there, lordship. So, lordship, at this list, lordship, only because of 24 days, lordship. No. That
Why?
cannot be.
Yeah,
He is not
No,
providing,
lordship,
lordship.
property, lordship, that everything has been seized, lordship.
No,
That
seizing
can be
and
break also, lordship.
seizing,
No point. No, if you do not give the passport, how will they?
seizing
That
and
I don't
lordship,
know, lordship, but,
even they
they are
themselves stated, lordship.
stopping, lordship. Only very that they arrested, lordship. Any condition, lordship, that 22 days the Assam government meeting, lordship, nothing under any special act, lordship.
No, lordship, because,
Purely
lordship,
on Assam
let the
government meeting,
investigation
lordship.
be to proceed to some extent. Because, lordship, once once they are released on bail, they will not, police cannot caught him because they are all out of Assam, lordship.
That cannot be a ground,
Okay,
lordship, to putting behind that. They will-
that is a ground, lordship.
That
That is a
cannot
ground,
be a
lordship.
ground, lordship.
Because
So how
once,
long,
because
lordship, that
why
they will be kept there?
they themselves said, lordship,
Oh.
they are coming from Bihar, lordship, and Bikaner and
Rajasthan.
lordship.
We are in Rajasthan.
Lordship,
Condition,
Bikaner and
lordship,
Rajasthan,
that
lordship.
will comply with the condition, lordship.
Let the investigation be proceed to some extent, lordship. But it is a very initial stage, lordship. Only 24 days, lordship.
Please read the FIR.
Lordship, page 11, lordship, with reference to subject cited, I would like to inform you that 29 so and so attempted convey information regarding the suspicion cyber related at the Salmara house at the house of Jairul Khan, Narul and Tamulpur PS was received by the undersigned. Accordingly, police party headed by the undersigned left toward Salmara 5 Tamulpur PS number so and so. On reaching the house of the Jairul Khan, local witnesses were called, but due to late night, none of them agreed to come to witness in charge. Accordingly, the charge in the house was made under videography and the presence of police witnesses. On entering the house, 8 numbers of suspected persons were found operating laptop and huge numbers of chain phone. On questioning, they could not provide any satisfactory answer as to what exactly work they were performing. The following digital instrument and the mobile handset were found used by them and seized 108 desktop, 2 numbers of laptops and 60 mobile phone SIM card and 50 numbers ATM cards and 13 mobile handset. The person were brought to Tamulpur PS for further questioning. From one apprehended person, namely Savan Kumar, it was found that they were working on behalf of trading company Sri Krishna Share Lordship. That is not registered one, Lordship. Krishna Share Lordship and commodity based in Noka, beginner Rajasthan. The company was verified through a website. It was found not to be registered as an intermediary. On the further inquiry and search the apprehended person phone, it was found they were actually involved in Hawala transaction and they opened several WhatsApp group in order to facilitate and keep record of such transaction. The suspect someone has opened WhatsApp group, namely Assam Parking, where two local person, namely Alam and Sariful Khan, were included, and details of the huge account of suspected illegal transaction has been recorded. The apprehended person were also found to be operating online betting so and so. Etc. in the laptop, reasonable ground to believe that they involve online betting by collecting money through Hawala channel and investing in different betting site and using the names of fake trading company, and found that they were suspected to register and the case below accused person for involving in the gambling and betting and showing premises to be used for all suspicion, lordship. 22 days has gone, lordship. Lordship may kindly go
Let
to
me see the CD.
kindly go to the case diary, lordship, if something has come up. All this suspicion, lordship. The main purpose is online betting, lordship. That is fact, lordship. And one company they were running, lordship, for stock that investment,
Trading
lordship.
company.
Lordship. Only that we can,
Unregistered trading.
lordship. That is why we could not submit you the details, lordship.
No, lordship, subsequently they have admitted, lordship, that is their Assam online, they are doing, lordship, that is IPL business, lordship, they are doing, lordship. That is initially they have stated, lordship, this is a company based from Bikaner, lordship, but subsequently they have stated, lordship, that it is an IPL, they are doing IPL business, Lordship, and Lordship, it is Assam online business that is named, Lordship.
No, that I understand.
So,
but see, they have
So,
admitted
Lordship-
what police has done for last 22 days. Lordship.
Police is
Anything
doing
in the
also
case that
in
he
each
lost.
and there are the numbers of cases in registered in every day, Lordship.
That is,
Police
these
cannot
all are
go
suspicion, Lordship. After
behind
saying-
only one case, Lordship.
After
Police is doing its own
saying
part,
60
Lordship.
days, Lordship, nothing will come out, Lordship. Most of the
Let their
cases-
statements be collected, Lordship. There, everything will reveal, Lordship, because.
Statement,
And
Lordship,
crime
like-
against society is not only the rape and others, Lordship. These are also the crime against society, Lordship. Because they are, all persons are involved in gambling, Lordship. Only the Lordship, heinous offense like
go to the Nigerian part
murder,
of the-
dokaiti, rape.
Submission-
This is not the crime against society. These are the silent killer, Lordship. These only because of this crime, Lordship, the society is doing, Lordship. Now it is, Lordship, everywhere, Lordship. IPL, Lordship. Everywhere, Lordship. IPL betting, Lordship. Everyone are involved in this game betting, Lordship. So, Lordship, this type of person come from Bikaner, Lordship. They are doing business here, Lordship. And we are simply saying, Lordship, they only because of 24 days, Lordship, we are releasing them, Lordship. No, Lordship, my strong.
So what if 14 and 15 says, Lordship, Assam Game and Betting Act, Lordship, punishment for betting, inviting, accepting, betting or possession instrument record, Lordship, is
Other
that
sections are also there, Lordship.
anybody who based on the invest betting possess an instrument of betting or other records shall be punished for regulation from not less than 6 months, Lordship.
3184.
Not less than 6 months, Lordship.
What about
The
61?
other allegations are not proved, Lordship.
62.
The other allegations that are suspicion, Lordship. No specific material, no specific has been shown in the FIR, Lordship. The specific incident is regarding the betting, Lordship, Assam Game and Betting, Lordship. That's a 6 months, Lordship, and 15, Lordship, says not exceeding 3 months, Lordship. 3 years.
Well, they will again go and again start the same business, Lordship, and everybody will be encouraged that only because of if they can remain only 20 days behind the bar, Lordship. Thereafter, again they will start, Lordship. It will be amount to encourage them, Lordship.
Please, sir.
Lordship.
investigation is very slow.
No, that
Nothing,
is-
nothing. They are not cooperating also.
So, Lordship, as per my information, Lordship, the passwords were given to them, Lordship. Passwords were given, and rather they are the employee of that farm, Lordship.
I know. They have
Lord-
stated like
Oh,
that.
Lordship, they are employee of that farm, Lordship, it is unregistered, so we could not produce the document, Lordship. And though, what they
I'll
had,
tell you,
Lordship,
I'll tell you.
Lordship.
They have brought on behalf of learned senior counsel, Mr. H.R. Chaudhary, learned additional PP, Mr. P. Bhattakur has submitted the CD is not up to date. Send back the CD corporate up to date CD list the matter on. Interim order shall remain in force till then. So it will continue interim order.
Item 24.
Timing for this matter.
Hmm?
For timing for this.
Standing already.
Yes.
Alright.
Obliged.
Lordship, on last occasion, interim bail was granted. The petitioner
You have
met the
the CD?
investigating officer.
Do you have the CD? 27?
On last occasion, your Lordship pleased to grant the interim bail, and your Lordship direction was to the petitioner should meet the investigating officer. According to your Lordship, there is a petitioner to meet the investigating officer. The allegation is under section 61.
Appeared statement recorded, madam.
Okay. What is your name?
My name is Devasri Chopra.
Edu order dated 4/4/2025 paragraph 1 to লিখি দিবা খালি নাম Mr. S.C. বিশ্বাসৰ জেগাত Miss S. চক্ৰৱৰ্তী
Devasri Chakraborty.
Miss D. চক্ৰৱৰ্তী লিখি দিবা paragraph 2 এটো লিখি দিবা paragraph number দিয়া নাই দেই চাই বুলি লিখি দিবা paragraph 2 লিখি দিবা হেৰি Mr. P. বৰঠাকুৰ DP গোস্বামী জেগাত paragraph 3 টো লিখি দিবা I have considered paragraph 3 পিছত তলত copy কৰাৰ পিছত লিখি দিবা I have considered the submissions at the bar. It is submitted that the petitioner have appeared before the investigating officer. So I have considered the submission that the petitioners have cooperated with the investigation and they have not violated real conditions. Therefore, the interim order dated 4/4/2025 is hereby made absolute under the same terms and conditions.
Great.
Send back the CD. 28 to শুনি ল'ব পাৰি বেছি লম্বা নহ'লে Will it be a long submission? It will be like elongated submission. Okay, then after break.
Lordship, in that case, item 30.
30.
Yes,
All right.
Notice was issued against the victim. Instructions were awaited from the PP's office
Okay.
regarding the completion.
30, item 30.
My lord, item 30, my lord, I have communicated with the OC concerned, my lord.
Ah.
They pray for 1 day, my lord.
Okay.
My lord, maybe matter may be fixed tomorrow, my lord, or any day, my lord, for only 1 day, my lord, for the service.
Please report on respondent number 2 is awaited. List the matter of item number 30. Day.
20.
Well, 33 also same, my lord, you have appeared,
Oh.
recorded our statement. 33.
33. 33 to Diasun. We haven't received a case diary, so we'll extend the interim order.
Interim shall come.
Okay. 33 to Likasun. Learned counsel Mr. S.C. is present for the.
Her name, my lord.
Okay.
You
Learned
know,
counsel Miss
Yunanda.
Yunanda is present for the 30.
Oh, then we will appear.
Okay, Yunanda is present for the petitioner. Learned additional PP, Mr. P. Bhattakur has submitted that charge sheet has been laid against the petitioner. Petitioners or petitioners?
Petitioner.
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 You are on interim bail?
Yes, Lordship.
The petitioner is directed to appear before the jurisdictional court stroke Elaka magistrate within 20 days and apply for bail, which may be considered by the learned court in accordance with law. Till then, full stop, till then, no coercive action to be taken.
Deep lord.
My lord, in item 30, my lord, CD to be retained, my lord, because CD is available.
The date may be fixed on 28. 26 and 27, learned counsel won't be available.
Item 32, item 32 at a line at Codiation. CD to be retained till 28. 32. Agar date ki disla rumi? 26 to 30.
Deeply obliged.
May I please your lordship? I am for the standing counsel of the CBI. Item number 25. It has been, just now I have come to know that in the morning it has been mentioned. It was not in our knowledge, and today the matter is fixed for CD. and interim protection has already been granted.
Item number 35 is not
No,
mentioned.
25 Lords. And on the garb of interim protection, they are not cooperating, the IO also, and they are not appearing. And today also they have already mentioned the matter and run away. Now the next date is fixed on 10th. Now they are trying to kill the time, not handing over the laptop and even the mobile phone. And the CD is available today.
Okay.
And without informing the opposite side. I am standing counsel for the CBI. And now they are running they are in the under protection, not cooperating the CBI. Up to date CD is there and IO has already written that he is not cooperating.
এইটো ৰিকল কৰি দিব পাৰি অৰ্ডাৰটো মাতি দিব অলপ খবৰ এটা দি দিলে হৈ যাব পাঁচবেলা 2টা বজাত
Or the matter may be fixed tomorrow.
আহি থাকিব
It may
Okay,
be
we'll
fixed
try
tomorrow.
to recall the order.
Much obliged.
We'll try. Otherwise, without their knowledge, then we'll
Yes,
not
that
record
is,
it.
but they are supposed to inform.
Yes, yes. Definitely, we'll try to recall the order.
Much obliged. So should I retain the IU with CD?
IO with CD.
Because it
I
can
don't
be
think they're
CD.
prepared. Better to be sent back, I think.
Much.
Petitioners not represented. Let me say, for the interest of justice, list the matter on.
My lord, I notice served, my lord.
We'll appoint a legal aid counsel.
My lord. Kindly, my lord, only short date, my lord.
Very short. date.
Friday, my lord, maybe. Friday not possible.
No. Legal aid counsel is
Long time, my lord.
appointed.
Yes,
Monday, next Monday.
my lord.
Learned counsel Mr. A.M. Babuya is present. Learned addition PP Mr. P. Bothak is present for the respondent number 1. Notice has been served to respondent number 2.
2, my lord.
And has submitted on your submission.
Yes, ma'am.
And has submitted that notice has been served on respondent number 2. Registry to appoint a legal aid counsel to represent the respondent number 2. List the matter on. 56 May. Item 8.
Notice served on.
We'll appoint a legal aid
Lord,
counsel.
Lord.
Learned counsel Mr. B.K. Gogoi is present for the petitioner and learned additional PP Mr. P. Bothaku is present for the respondent state and has submitted that notice has been served to respondent number 2. Stop. Registry to appoint a legal aid counsel to represent respondent number 2. List the matter on 28 May. Okay.
Obligation.
Standing item 24. Item 24. Petitioner is not represented. 1 minute. Item nearly given. Okay. Later on লিখি দিয়া এইটো আগতে লিখিছিলা তুমি আসলা ন তাৰপিছত later on লিখি দিয়া later on learned standing counsel
Yes,
for CBI
for CBI.
Miss M. Kumari has is present and has submitted that the
Matter-
petitioner has been taking adjournment on frivolous grounds, despite the fact that the CD was in this court today. Send back the CD.
And
Call
my
for the
humble
CD or-
submission before your lordship. In the CD also, it is reflected, he is not cooperating. Of course, on
No, giving of notice
Is
is also
coming, but
submitted
is
that the
not handing
petitioner is
over
not
the laptop
cooperating with
and
the petitioner, one petitioner. One petitioner. One. It is also submitted that the petitioner is not cooperating with the investigation. This the matter on 2019. Interim order to থাকো। থাকো, দুটো থাকো। মাঝ হয়। Interim orders are remaining for till then.
So we'll have to come with CD.
Yes, we are calling for the CD.
So
Send back the CD, call for the CD on March.
My pleasure, Lordship. Your Lordship, it's a charge sheeted matter. LCR was called for your Lordship.
NDPS.
Pertaining POCSO, your Lordship. FIR is at page number 11, your Lordship.
Only the injury report minor we have not received minor, otherwise they have appeared minor, statement recorded minor.
Basically, it's a family claim.
Minor stated that they yet to minor receive the minor collect that minor injury report minor. Some
Into
photograph.
paragraph number 1 লিখিবা order dated 10/4/2025 paragraph number 1 এটো এর কে বৈশ্য লিখি দিবা paragraph number 2 paragraph number 3 paragraph number 4 I have considered the submissions at the bar with circumspection and I have also scrutinized the case diary. The petitioners have appeared
Petitioners.
before,
Petitioners, my lord.
petitioners have appeared before the investigating officer and the statements have been recorded. The petitioners have not violated any bail conditions and they have cooperated with the investigation. Considering all aspects, the interim order dated 10/4/2025 is hereby made absolute under the same terms and conditions.
Deeply
Send back the CD.
Minor, send back.
Obligation.
May I please order? If the FIR is in page number 15. May I read yours?
You are on interim way?
Yes, ma'am.
Interim.
One per petitioner?
Madam, there are three
petitioner.
numbers of petition. Madam, in the cause list, one name is minor soul, my lord.
There are 3 petitioners, Lordship.
Okay, okay.
May I read the FIR?
No, not required. What is your name?
MS K Bharali.
Third learned counsel, Miss K. Bharali. Okay, paragraph 1 लिखी दिवा. Paragraph 2. Paragraph 3. Order dated 29/4/2025. What is the type of injury?
My lord, here, my lord, the case is that, my lord, the informant's son, my lord, who is a student of a particular college, my lord, there is the altercation take place between the kids, my lord, and as a result, my lord, he got injured, my lord. Now, present, my lord, the petitioners, they are all 3 are the authorities of that school, my lord. The allegation is that the father of the, my lord, that is the injured son, when approached the authority, they said that he will go for the hospital and we will pay the amount. As because that amount was not paid, only because of that, the affair was launched. This is the case.
Anyway, the type of injury?
Injury is, my lord, fracture.
Reverse.
That it is a fracture, my lord, the boy got fractured, my lord, and my lord, his operation was done in Patna. His statement is also there, my lord.
Previous injuries on his head.
My lord, my lord, that is in the hand, my lord.
Hand.
Hand, my lord, some plate was, my lord, that is there. Statement of both is, my lord, take mark, my lord. Why not? Okay.
You have the injury report here?
But an injury report I am not getting, or otherwise,
That
my
was,
lord,
I am also.
we
sitting
can
for
fix
the
it in an up-to-date CD maybe call for my lord. For the injury report.
But these are,
But my lord, the allegation is not
Yeah.
against them. There is an altercation between
Not
the
because-
boys, my lord. When they are playing, my lord, the quarrel.
paragraph 3 বুলি ক'লো না? I have considered the submissions at the bar, and I have also scrutinized the case diary. The petitioners have appeared before the IO. Petitioners number 1, 2, and 3 have appeared before the IO, and they have cooperated with the investigation. Only 3 petitioners?
Yes.
They have not violated any bail conditions. The petitioners are also willing to cooperate with the remaining part of the investigation. Considering all aspects, the interim order dated 29/4/2025 is hereby made an absolute under the same terms and conditions sent by the CD.
Wait, please, your lordship.
Hmm.
The CD was called for, my lord.
Yes, it's.
ICM 35, my lord, CD receipt, my lord. But my lord, I am not able to go through the entire CD, my lord. The
You'll wait for
numerous
1, 2
parts
days?
are there, my lord.
1, 2 days?
My lord.
For 2 days? 1 day, 2 days?
Friday, my lord.
Friday?
Friday.
Learned Senior Counsel Mr. T.J. Mohanta is present. Learned Additional PP Mr. K. Bose has submitted for fine. Go to the city which he has received today. List the matter on Friday. 23rd.
Deeply open.
Deeply open.
Yes, yes.
Item 36, 37, and 38 for orders. Well, should it- sorry. No, no, division. Division.
You have IA? You want to submit on IA?
No,
What
no,
about the,
there is no I, my lord. Last occasion also probably they are not there. They are challenging, my lord, the jurisdiction of the special court, my lord. And there are 4 petition filed. One is already withdrawn. No, আমি I filed কৰা নাই. I am on behalf of the High Court, my lord.
last time also they were not here.
Not here, my lord. Probably conviction is already upheld. Already, my lord, before there is appeal pending, my lord, now it is.
WP criminal.
My lord, WPC criminal.
What is it? Article 226, 227.
227, my lord, they are constitution of the special court that says that that is not as per law. Now they are challenging. So they are actually, my lord, at that point of time, judgment was just to deliver that the Rakesh Paul case. Then, my lord, they challenge that man.
Okay.
That matter, my lord. In fact, my lord, they earlier also they went to up to the Supreme Court. There is no exaltation passed. Probably now they lost, my lord, interest, my lord. Anyway, my lord, your lordship give him another chance, my lord, after 1 month. Yes.
Oh, today,
They are also not present, my lord. You are from.
They are not present, no?
By precision.
Oh, he is present for the state, I think.
He's present for state. I am for the High Court, my lord. The here also, my lord, petitioners are not present. So let them another chance, my lord.
You want to give them another chance.
At least, my lord.
You do not want this petition to be dismissed.
No, if that is up to your lordship, my lord. Earlier occasion also they are not present. I am just pointing out. Probably.
Yes, 2 days they are not present.
Actually, sorry. Well, doing it.
Good then, one last chance. Petitioner is not represented today. Learned Senior Counsel Mr. TJ Monto is present for the respondent number. How many?
4, my lord.
Only respondent number 4.
My lord.
Respondent number 4. Learned Counsel Miss R. Gogoi. Government Advocate. Learned Government Advocate Counsel Government Advocate Miss R. Gogoi is present for respondent number 2 and 3. Learned Additional PP Mr. P. Bodha who is present for the respondent number 1 state. Respondent state. Anybody else? List this matter on absence of any of the parties on the next date fixed. Necessary order may be passed. 24 June.
May it please your lordship. Lordship, be pleased to take up the
I-
lordship.
Wait.
No, bill.
Lordship, there is a correction of an order, lordship. Only 2 paragraphs, lordship, where an error has corrected. Correction, lordship. In fact, my lord, my
Correction,
brother does not have any objection.
No objection.
No
Lordship,
objection.
only the point that in
Which
terms of
paragraph?
lordship, para 5 of the order, lordship may be pleased to come at page number 11. Lordship. Para number 5. Para number 5, lordships, fourth line from the above. Petitioner, where is the contempt petition? Lordship, this ought to have been the complaint petition. That was a complaint petition, in fact.
What petition? Complaint.
Complaint petition, lordships.
The
And
Excel
para
complaint
number 11, lordship.
Contempt.
Contempt. And lordship, para number 11, lordship. Further proceedings of the contempt case, lordship.
Pretend.
Lordships,
This is my order.
lordships, clerical error has crept in, lordship. That is what, lordship. It's a clerical kind of thing, lordship. Bona fide inadvertence, lordship.
I don't know how I missed it.
No, lordship, it ought to have been by the stenographer, lordship. Lordship has dictated it correctly because your lordship that it is a complaint petition.
And a
Down
complaint
below it comes to
petition,
contempt petition,
contempt
lordship.
petition লিখি দিলা তুমি। হ'ব একো নাই, correction কৰি দিবা। এইটো contempt লিখা আছে। Our learned counsel, Mr.
H. Pitala, lord. H. Pitala, lordship.
S.
H. Harish Pitala, lord.
H. Pitala. For the
Petitioner, lordship. Petitioner
for the
applicant.
applicant. I've just checked it. It's
Meet
there.
me, lordship.
Contempt. For the applicant. Vinod Kumar Surana.
For Vinod Kumar Surana. He's the accused in the court below, lordship.
Okay. Who has filed his application for modification, alteration, rectification of the order dated 23/7/2024 passed by this court in criminal petition number 837 of 2024. Heard Mr.
P. Sharma on behalf of respondent number 2.
B. Sharma, learned counsel for the respondent number 2, Narendra Surana, and Mr. P. Botago, learned additional PP Assam for the respondent number 1. The petitioner has filed this application stating that
Lordship, categorically stated in para number 4, lordships.
that in the order dated 23/7/2024, passed in criminal petition number 837 of 2024, an error, typographical error has crept up in paragraph number 5 and paragraph number 11 of the order. So it is submitted that instead of typing the word complaint, comma, the word contempt has been typed in the fourth line of paragraph number 5 and in the first line of paragraph number 2. Inadvertently, full stop, inadvertently, inadvertently, full stop, period. After considering the submissions at the bar, comma, this application is allowed for correction of the word full stop. Instead of the word contempt, the word complaint is to be typed in the fourth line of paragraph number 5 and first line of paragraph number 11 of the petition. This order will also petition order dated
3/7.
23/7/2024. In criminal petition number 837 of 2024. This order will also form a part of the order dated 23/7/2024 in criminal petition number 837 of 2024. In terms of the above observation, this I stands as full stop.
And my lord, main case criminal petition kindly fix for admission hearing on solemn lordship. Because
Lordship.
we have already filed a.
Their reply, they have already filed, Lordship. And we would like to prefer a reply to their contentions, Lordship. So
This
matter
was
may come
not
up for
admitted
final.
by this order.
Lordship has admitted.
Okay, not admitted.
Lordship, the order for admission is not there, Lordship.
Okay.
That is only an
Not
equal stay
admitted, okay. List this matter for admission
for admission.
Kindly date.
next week. List this matter. You want to
We have
take?
some difficulty, Lordship. Lordship, we will like to reply to that affidavit which they had filed in opposition. We'll file a reply to that.
Where is the path?
Lordship,
2
only
weeks, 2 weeks. List this, you want a
after
date?
the.
Do you want to?
Yes, Lordship.
It will main case to list this matter for admission on. Meanwhile,
Meanwhile,
you'll file a.
We'll file a reply to this, Lordship. Meanwhile. I'm deeply obliged.
May please also. My lord, the IA has been filed, my lord, for small correction, my lord.
Okay.
In fact, my lord, the CD, my lord, has not received, my lord. Lordship may fix this matter for bail hearing, my lord. This IA may be kept pending, my lord. That may be considered in the, my lord, date of final disposal, my lord.
I don't know. List this matter when do you want?
My lord, any date, lordship.
Okay, then any date. 3rd June.
7 June, my lord. 3rd. My lord, interim order passed earlier, maybe.
Interim order shall. In this IA?
No, my lord, in the main, PA, my lord. That interim order dated, my lord, 4/4/2025.
Main case of Likhi River. This is already listed on.
That list 16/5, it has not been listed.
It was listed, not listed.
Not listed, my lord. Today, my lord, it is.
Both the parties are represented. It main case of Likhi River. Interim order shall remain in force till the next date of listing. Why was it not listed
My lord,
on 16/5?
My lord,
As if you had outer line by Diva, as this matter was not listed on 16/5/2025, interim order is extended up to the next date of Clerical. Interim order shall remain in force now. Next date, Kiria, how is that? So I'll extend the interim order, okay? There was an interim order, it was not listed. I don't know why. Maybe because of the IA.
no, my lord, otherwise the main case is fixed. IA, my lord, it has been filed on 7/4, long back. Anyway, my lord, on 3rd of June. Obliged. In that.
Also call for the CD then?
Yes, CD has already.
You have received a CD?
No, no one.
Call for the CD.
Should kindly take the item 42 first. So this is also my case, Lordship.
Item number?
42.
It is case 41. What about the 41?
Yes, I am just finishing this. I will take Lordship. I will.
42,
Lordship.
43, 44. All three are regarding same issue, Lordship. So Lordship may have all the
42?
up to 42, 43, 44.
42, 43, 44.
No, Lordship, kindly see Lordship in 42 Lordship. I am just submitting Lordship. 42 Lordship.
Yes, you can submit later. I will let the submit later on.
Yes.
Because
Lordship.
41 is
Lordship,
41 is
no.
voting. Then why he is calling for 43, 42, 43? I don't
No,
know.
no, I'm calling 44, 43 not. I am only, Lordship, my item is 41, 42. So I like to take 42 first, Lordship. This is my case. 42, Lordship.
41 and 42.
Yes, my case, Lordship.
The issue is Lordship regarding the judgment, the arrest is prior to the 310 or 23 or not, Lordship. That issue. That Lordship 41 is after Pankaj Bansal judgment. And 42 is Lordship, 42 is before Pankaj Bansal judgment. And 43, 44, all these are before Pankaj Bansal. That is why I am submitting Lordship that all these three matters can be taken up.
Lordship, just I have few submission, Lordship.
42, 43 and 44 together.
Yes, Lordship, yes.
Yes.
Then 41 first, Lordship. My 41 I take, Lordship. 41.
41.
Oh. Lordship, here the petitioner was arrested on Lordship 13/8/2024, Lordship. And Lordship, here SARS also.
When? 13?
Lordship, 13/8/2024. 13/8/2024, Lordship. He was sent to jail, Lordship.
Okay.
Yes, Lordship. SARS was framed, Lordship, on 18/1/2025.
18/1.
18/1/2025, Lordship. And there are 10 witnesses. None of witness was examined, Lordship. And my main plea, Lordship, is the non-communication of ground of arrest, Lordship, which I have annexed, Lordship, the arrest memo 34, Lordship. And in the record, Lordship, I have flag mark, Lordship. Yellow flag mark, Lordship. There is no ground of arrest, Lordship, communicated to the petitioner. On that ground itself, Lordship, the present petitioner was entitled on bail. Lordship, I have, Lordship, the orders passed by your.
In the record, you have flag marks,
Yes, Lordship, in the record.
but
Yellow
you have
flag
not
mark.
given any.
Yes, I have
copy
given.
here.
I have given, Lordship. Arrest
Which was
memo and
annexed?
yes, Lordship. Sir, this is page 34 and 35.
Okay.
Yes, Lordship. Recently, your Lordship has passed one order. I have just like to rewrite.
And what is the contraband?
In Lordship, I am coming to Lordship. In that case, Lordship, this is order 14/5/2025. And my Lordship, contraband, yes, Lordship. Lordship, it is a list 8,000, Lordship, 8,000 blue zipper.
What?
Blue zipper, Lordship, kindly see in the FIR. It is written. Lordship, marking as
Where is the
suspected. Yes. Page 11, start from page 11, Lordship. It is page 12 and 13, the relevant portion, Lordship. The suspected narcotic drugs tablet marking are blue zipper packet. It is a suspected, Lordship.
Page 11?
Page 13, Lordship.
Okay.
Yes. It is suspected, Lordship. It is recovered from a night super bus, Lordship. Under the seat, Lordship, it is allegedly the seat of the present petitioner in the back, Lordship. So in that, Lordship, The order I have already provided. Your lordship, in that case also,
Been examined now?
none of the witnesses.
No.
are not. In that case, lordship, your lordship, I am just one line, I am just, your lordship expressed that I am hesitant to grant bail as investigation has progressed considerably and the case is at the fake end of the trial. However, a close scrutiny of the trial reports reveals that the ground of arrest have not been communicated in a manner understood by the
This is
petitioner.
my line.
Yes.
Not to me.
Lordship, in that case, lordship, lordship allowed. So kindly this petition will be allowed. Yes.
Which line? Last line.
No, lordship, this is the paragraph 31. Your lordship referred the Bihankar judgment in paragraph and details, lordship, the conclusion, lordship.
All right.
Yes, lordship.
I know it is on the ground of only there is the arrest, man. If my learned can state it, then my lord, law is my lord, today's law is very clear. Because the arrest is after my lord Pankaj Bansal, my lord, 3/10/2020. So this is my lord. Because it is arrested on 12/8/2024. But if my lord on the my lord married, then again I have to go to the answer. But only that point, my lord, then regarding the Bihar is settled provision
So
of law.
this, he has to be granted bail.
My lord, because my lord, now it is my lord.
Because
On today, because warly hit and run case, my lord, that is still pending, my lord. We are waiting for that one.
Where?
My lord, that is another case, my lord. There is the warly hit and run case, my lord. That is pending, my lord. The same
Pending.
issue from the Bombay High Courts, my lord. That is pending.
Okay, see, there are no objection.
Yes, lordship.
So why did you give such a long submission?
No, lordship. Okay.
Third learned counsel, Mr.
Azad Ahmed.
Azad Ahmed for the petitioner. And then why were you hesitant to place this submission also?
Lordship.
41, you kept on insisting on 42, 42.
No, lordship, in my
Sahadal
item 42, lordship.
who has filed his application under section 483 of the BNWS 2023 with where both bail as the petitioner is behind bars since 8/13/8
Yes, yes.
2024 in connection with official N
Yes.
within bracket N case number 249 of 2024 arising out of so and so PS case under so and so sections. It is submitted on behalf of the petitioner that the petitioner has been incarcerated for a prolonged period without proper trial. Full stop. 10 witnesses are enlisted in connection with this case, but not a single witness has been examined so far. Full stop. It is submitted that the grounds of arrest has not been communicated to the petitioner in the manner understood by the petitioner. Annexure
Yes, lordship. Annexure 6 series, lordship. Take page 34.
Page?
Page 34 and 35.
This is arrest memo, no?
Yes.
Annexure 6 is the this is under section 60B.
Lordship, that is why, lordship, in the record, I have like marked there are nothing, lordship.
Annexure this arrest memo also or actually.
Yes.
All right. Annexure 6 series is the arrest memo, which clearly reflects that the grounds of arrest has not been communicated to the petitioner.
Yes,
The
lordship.
petitioner has also
Yellow flag.
drawn the attention of this court to the trial court's record.
Yes, lordship.
Where
Continue,
the
lordship. Yellow flag.
notice
Continue.
under section
Continue, lordship. Page internal page 25, I think. Yellow flag.
page
Internal page 25. This is a lordship. There is a wooden pen written 25 page number. Wooden pen.
Okay.
Yes.
Notice under section 47 of the BNWS, where the grounds of arrest has also not been mentioned in a manner understood by the petitioner. The petitioner has also relied on the decision of the Honorable Supreme Court in Kobe Bukasta versus State of NCT Delhi reported in which year?
Yes, Lordship, I mean,
Reported in
yes, Lordship, I am the Purvi Puras Lordship, 2024 8 SCC 254. 2024 8 SCC 254.
Thank you, huh?
Only, my lord, that part may be recorded, my lord, because it is pending, my lord. That's my humble.
2000,
2024 8 SCC 254 Purvi Puras.
wherein it has been observed that a yata judgment ka diya ase bail application number 1268 2025 more judgment ka etu bhai diba ha italics kini para 20 or 22 italics kini bhai lo. The petitioner has also relied on the decision of the Honorable Supreme Court in Vihan Kumar versus State of Haryana.
Yes, sir. Reported
Reported in
2025 SCC online SC 269.
wherein it has been observed that the italics kini para 21 kini bhai diba. Para 21 22 next page of the class. The learned additional PP Mr. K. Bosha, who has raised serious objection and has stated that the petitioner was apprehended during Naka checking.
Within Naka checking, from
During
his
Naka
conscious
checking,
position, ma'am.
and as the contraband was seized from his conscious possession, the petitioner is not entitled to bail on the grounds of arrest as on non-communication of grounds of arrest as at the time when the petitioner is on the run, the grounds of arrest may not be, could not be. When the petitioner was on the run, the grounds of arrest could not be communicated to the petitioner as his immediate arrest was inevitable, full stop. The petitioner has relied on the decision of the Honorable Supreme Court in connection with SLP criminal numbers 17132 of 2024 and other SLPs
Mihir Rajesh Shah versus State of Maharashtra. Another.
in Mihir Rajesh Shah versus the state of Maharashtra
And another, my lord.
and another wherein it will
Right order, my lord, this
wherein
order dated 22/4/2025.
I'd order dated 22
22/4/2025. First, my lord,
22
first,
2025.
my lord.
It has been observed that para 3 only.
Para 3 only, my lord.
Para 3
Only
that is
the-
yes, I have considered the submissions at the bar with circumspection. In the light of the decision of the Honorable Supreme Court in Vihan Kumar's case, Supra, and in the case of Provi Pukasto Supra, it appears that bail may be granted to the petitioner. The petitioner is hereby enlarged on bail of ₹1 lakh with 2 local sureties of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall refrain from such activities with which is alleged. Is from that place?
Yes, Lordship.
From that place?
Yes.
The petitioner shall not leave the jurisdiction of the court without prior permission till completion of trial, and the petitioner shall not exercise threats to the witnesses or try to influence them. On breach of any of the bail conditions, bail order shall stand automatically cancelled.
Lordship, item 42, Lordship. And the Lordship, I would like to first point it out, Lordship. Here
I'm
the-
getting really saturated with this Provi Pukasto and this.
No, Lordship, I'm just,
I'll take it up tomorrow.
Lordship, kindly,
Not
a
today.
little, Lordship,
You
I will
be
take, I
submitting
will,
that Pankaj Bansal only.
Lordship, I will take 5 minutes then, Lordship, because in this case, the co-accused already granted bail by the trial court, Lordship. There's a record in the record.
Then why you don't approach the trial court, withdraw this case and approach the
Yes,
trial
Lordship,
court?
one Lordship, he is relying that prospective and retrospective, that effect, Lordship.
No, I won't want to, I don't.
Lordship,
want to
just
listen to it again.
one judgment, Lordship, I have already get ready, Lordship, kindly.
Since
provide it.
morning, that same.
Yes, Lordship, just one, Lordship, one judgment, and yes, yes. Because perhaps my learned friend, he argued the matter earlier in another court, as far as my knowledge is concerned. So I'm not good that aspect, Lordship. One Lordship judgment, kindly come to paragraph 8, Lordship. The law regarding
Paragraph 8, yes.
retrospective and prospective, Lordship. I'm just reading, Lord. Kindly. Now the law of prospective, Lordship can get this, Lordship. paragraph 8, next page, Lordship. Now the law of the prospective and retrospective operation is absolutely clear. Whereas a law made by the legislature is always prospective in nature unless it has been specifically stated in the statute itself about its retrospective operation. The reverse is true for the law which is laid down by the Constitutional Court. This is the Supreme Court, Lordship, or law as it is interpreted by the court. The judgment of the court will always be retrospective in nature unless the judgment itself specifically stated that the judgment will operate prospectively. Lordship, let him show whether the
It has been mentioned in Pankaj Bansal's case.
Lordship, it has
About the prospective effect.
Yes,
It has been mentioned in Pankaj Bansal's case.
It is a common law also that when judgment is not declared as a retrospective or prospective, then it will be retrospective. It's common law. There is no new, nothing new in that fact law. But I'm going to submit something else first. Why Pankaj Bansal is prospective stated and why Bihan Kumari is cannot go to retrospective? That I will submit first. It is common. It is known. To, it is common law that when there is nothing mentioned in the whether it is prospective or retrospective, it will be retrospective. But when their retrospective effect will not come, that I will submit first.
Let him submit them.
Lordship.
Let him submit.
Yes,
Because he will take the Vihan Kumar. So why should I go over and over again since morning?
Yes, Lordship.
Vihan Kumar and Prabir POCSO. Why should I go over and over again?
Because Lordship, no.
No, what is because?
No, Lordship,
I know the paragraphs and I know everything.
Yes.
You will be submitting.
No, I'm not what beyond Lordship.
So why do you want?
No, Lordship, I'm not submitting.
Just point me the pages.
Yes, Lordship.
Just point me the pages where the notices are annexed.
Yes.
Just point out the pages where the notices are annexed.
Then Lordship will pick the matter tomorrow. Then Lordship will, the matter other councils are there.
Yes, you can submit. Point out the pages today. You can point out the pages today where you have annexed
Yes.
notices.
Yes. Notice I have finished. Yes, Lordship. Lordship page 23, 24. Lordship.
You also come. 44, 43.
43 my lord,
Just point out the pages of that and then
44, I had some other ground also.
So that can be had.
Accused was granted bail on the ground of
Is on-
prolonged incarceration by your lord.
let them complete, then you will
Yes,
submit.
Lord.
Yes, Lordship, my
44, you have some other ground, okay?
43 also I have other grounds. 43.
Only 42.
Yes, sir.
Okay, all right then. 42, then page.
Page Lordship 23, 24.
Lordship, one thing is that Lordship in 42, 43 Newton, 43.
Page
For page 23, 24.
23 and 24, these are the notices.
Yes, Lordship.
So only on grounds of arrest you are praying for.
Yes, Lordship. Other aspect, Lordship, the court, Lana trial court on last Lordship 17/5, the person, the home possession, the contraband was says Lordship, he has been enlarged on bail.
Okay.
Lordship, from my
Grounds of
possession,
penalty.
yes, from my
accused.
possession, nothing has been
accused.
recovered, Lordship, from my possession. It is on the record, Lordship.
Whom drugs recovered, granted bail.
Yes, Lordship. Kindly, I have flag mark, Lordship, in the court record, Lordship.
Granted bail by trial court.
Trial court, yes, on 17/5.
All right. And then which page? That bail order?
Lordship in the record.
I'll search.
Yes, Lordship, record, I flag mark, marks.
Huh?
In record, I have.
Even the index, no? You had the index in the record?
In the records, yes, Lordship, I flag mark in that order.
Oh, you have flag mark also.
Yes,
okay.
yes. And the pink flag mark, Lordship.
And how many days you are behind bars?
Lordship, 1 year, 8 months, 9 days.
How many witnesses are
There are
examined?
14 witnesses, Lordship.
14
14
witnesses.
Yes. Admittedly, there is a progress in the.
How many witnesses? are
Yes,
examined?
12, Lordship, 12, yes. There is a progress, Lordship, because,
The trial.
yes, Lordship, because on 17/5, Lordship, the person whom possession the contraband was recovered, he has been enlarged on.
What is the contraband?
Contraband here, Lordship? 1296 number of Ismex tramadol hydrochloride acetaminophen, Lordship.
Tablet, no?
Yes, Lordship.
1000
1296.
tablet,
Yes, Lordship.
Tramadol.
Yes, Lordship.
Okay. I'll hear your submission because this is at the end of the trial. I want a serious submission,
Yes.
please.
Regarding Lordship. Regarding what is Lordship? That
This. His case on grounds of arrest, solely on grounds of arrest.
Lordship, here in this case, Lordship, today this case was fixed, Lordship. Earlier we have submitted, Lordship, that as there are 3-4 judgments came regarding the issue of Article 22, compliance of Article 22(1). First, Pankaj, earlier there are some judgments, but earlier the effect came into from the Pankaj Bansal judgment also. That Pankaj Bansal judgment came in 3/10/23. And in that judgment, Lordship, it was specifically stated, Lordship, the effect of that judgment will be prospective, Lordship. And thereafter, some judgments come, Ramkishore Arora come, Lordship, Prabir Burkas come, and thereafter, Bihan Kumar come, Lordship. Wherein there is nothing mentioned, Lordship, that whether it is retrospective or prospective, Lordship. There are some languages, Lordship, which I will point out, Lordship, that even in Bihan Kumar judgments, Lordship, the court has specifically directed to the prosecution or the investigating authority that therefore, if required, the rule may be changed. That is also there. So we cannot say it is blanketly that it is a retrospective. Though it is not mentioned, retrospective effect may come, but the languages are like that, Lordship. Even though, Lordship, Pankaj Bansal judgment, Lordship, as there was earlier in Article 22(1), there is nowhere mentioned that how, whether it has to be written or not. The arrestee has to be informed. That is the language, Lordship. And when Pankaj Bansal came, it is specifically mentioned that prospective and it has to be written. Thereafter, after Pankaj Bansal, Lordship, Ramkishore Arora came, Lordship. In Ramkishore Arora case, Lordship, the paragraph, Lordship, I have submitted that. Lordship.
Yes, paragraph.
Pankaj Bansal judgment, I think I do not need not to read again, Lordship.
Yes, yes.
It is henceforth, it is every knows, Lordship. In Ramkishore Arora case, Lordship, para 23, Lordship, that I have, Lordship.
Para 23.
The last paragraph, Lordship. Last page, Lordship. As discriminable from the judgment of Pankaj Bansal case, also noticing inconsistent practice being followed by the officers arresting the person under Section 19 of PMLA, directing to furnish the grounds of arrest in writing as a matter of course, henceforth, meaning thereby from the date of the pronouncement of the judgment. The very use of the word henceforth implied that the said requirement of furnishing grounds of arrest in writing to the arrested person as soon as after his arrest was not mandatory or obligatory till the date of the said judgment.
Nicely, clearly stated.
Lordship, it is clearly stated, Lordship. Thereafter, Lordship, another judgment came, Lordship, that is Probir Purkast, Lordship.
There you have to write.
Lordship. Here also, Lordship, para 45, Lordship.
Para 45.
Lordship. May I read, Lordship? It
Yes.
was the fervent contention of learned ASG that in the case of Ramkishore,
45.
Lordship,
Probir Purkast.
Probir Purkast, Lordship.
Para 45.
45, Lordship. Last bit, almost last.
Okay.
Learned ASG that in the case of Ramkishore Arora Supra, a 2 judges bench of this court interpreted the judgment in the case of Pankaj Bansal Supra to be having a prospective effect and thus the ratio of Pankaj Bansal Supra cannot come to the applicant's aid. Indisputably, the applicant herein was remanded to police custody on 4th October 2023, whereas the judgment in the case of Pankaj Bansal Supra was delivered on 3rd October 2023, merely on a consensual textual submission regarding the late uploading of the judgment. Learned AG cannot be permitted to argue that the ratio of Pankaj Bansal would not apply to the present case. Hence, the plea of Sri Raju Learned ASG that the judgment in Pankaj Bansal Supra would not apply to the proceedings of remand made on 4th October 2023. It is impliedly it is admitted, Lordship, that Lordship for 4th, as it was arrest was 410 and Pankaj Bansal was 310, that is why it is not acceptable. But in then Lordship may kindly come to the last paragraph 51, para 51. On what basis? As a result, the appellant is entitled to a direction for release from custody by applying the ratio of the judgment rendered by this court in the case of Pankaj Bansal. The ratio was applied from the Pankaj Bansal. So, admittedly, this was it was also from reading the paragraph 45 and 51, it is implied that it is prospective has been accepted. Confirms. Thereafter, Lordship, Bihan Kumar's judgment came, Lordship, wherein Lordship, though there is no specifically mentioned, conclusion 21, conclusion paragraph is 21.
Yes.
Though there is no specifically mentioned, Lordship, in Lordship may kindly come to para 33 E.
33E, yes.
The state of Haryana said issue guidelines, departmental instruction to the police. 1. To ensure that the act of handcuffing an accused while he is on a hospital bed and lying him on the hospital and tying him to the hospital bed is not committed again. 2. To ensure that the constitutional safeguard under Article 22 are strictly followed. If necessary, the state government shall amend the existing rule guidelines. Lordship. Thereafter, Lordship, one more thing, Lordship, I would like to point out, Lordship, from the paragraph, Lordship, that is, Lordship, there are 3 of the N Petitioner Justice N Petitioner Singh judgment, Lordship. That Lordship may listen. The purpose of inserting section 50A.
Yes.
Lordship, I will read it later on because it will go in another way, Lordship.
Yes.
Why this article, the motive of Article 22(1) will come, that will I will read later on, Lordship, because now I am on prospective retrospective. So, Lordship, as we have gone through the three judgment, Lordship, and in each judgment, Lordship, the Pankaj Bansal, Ramkishar Arora, Prabir Purkastra, in each judgment, Lordship, it has been stated that written ground of arrest has to be given and after 3/10/23. Thereafter, as Bihan Kumar's judgments has not stated nothing. So, as the common law, that commonly it is presumed that when there is when it is not mentioned that whether it is prospective or retrospective, it will go retrospective. But when 3 judgments are there, Lordship, then we have to see, Lordship, what is the strength of the judgments, Lordship. In each and every judgment, there are two judges decision are there. It is not that Bihan Kumar is 3 or 5 like that, Lordship. It is only 3. Then what we will see, Lordship? Why we will go only by the Bihan Kumar? Why will not go to the Pankaj Bansal, Lordship? Only because that it is subsequent.
No.
We cannot go, Lordship. That is why, Lordship, in there are some judgments, Lordship. If the second judgment, subsequent judgment is not stated anything regarding the issue, ratio that not discuss the entire ratio, then it will be treated as a paraemporium. And regarding to that aspect, Lordship, I have submitted one judgment, Lordship, and that is, Lordship, Sandeep Kumar Bafna. That is Sandeep Kumar Bafna judgment, Lordship, and here in this judgments, Lordship, Lordship will find, Lordship, paragraph 19 and 20. When a judgment is paraemporium, Lordship.
Yes, yes, this is the famous case relating to
Lordship,
how to interpret judgment.
judgments, Lordship. Paragraph 19.
Paragraph 19, yes.
19, Lordship. It cannot be overemphasized that the discipline demanded by a precedent or a disqualification or diminution of a decision on the application of the per inquirium rule is of great importance, since without it, certainty of law, consistency of ruling, and committee of courts would become a costly casualty. A decision of judgment can be per inquirium, any provision in a statute, rule, or regulation, which was not brought to the notice of the court. Here, Lordship will find that regarding while deciding the issue of prospective or retrospective issue, that court is silent. Bihan Kumar's judgment is silent, but other court has decided that issue. But in that judgment, Lordship, that judgments were also discussed. But while discussing that judgments, Lordship, Pankaj Bansal, Pravir Purkast, Ramkishore, or but that part has not been discussed, wherein it is specifically while going through the Pankaj Bansal judgments, the ratio is that is the paragraph 35, and while reading the ratio, it is simply henceforth, but that is not discussed here, so it is per inquirium, Lordship. A decision or a judgment can also be per inquirium if it is not possible to reconcile its ratio with that of a previously pronounced judgment of a co-equal or larger bench, even the larger bench also.
Yes.
Or if the decision of a high court is not in consonance with the views of this court, it must immediately be clarified that the per inquirium rule is strictly and correctly applicable to the ratio decidendi, not to the obiter dicta. Here the ratio decidency is that residency is that, Lordship, it is written argument, written ground of arrest, and from when that ratio is discussed. And obiter dicta. It is often encountered in high courts that two or more mutually inconsiderable decisions of the Supreme Courts are cited at the bar. We think, it is important also, we think that the inviolable recourse is to apply the earliest few, as the succeeding ones would fall in the category of per inquirium. Para 20, validation of ratio. This is in Nagaranjan's case, Niranjan case. We must now discuss the detail, the decision of a two judges bench in Rasmi Rekha Tattai versus State of Orissa, for the reason that in the impugned order, the single judge of the High Court has proclaimed, which word we use intentionally, and Niranjan Singh's is per inquirium. The chronology of cases mentioned in Rasmi Rekha elucidate that there is only one judgment anterior to Niranjan Singh's, namely Balasan Singh Jain versus State of MP. Here the numerical counting has come thereafter, Lordship. How the numerical, that will come, Lordship. Because in Niranjan Singh case, Lordship, only one subsequent judgment come, which along with the Constitution bench decided in Gurbakh Singh Sabha, intrinsically concert itself only with anticipatory bail. It is necessary to give a salutary clarion caution to all courts, including the High Court, to be extremely careful and circumspect in concluding a judgment of order. The learned single judge appears to have blindly followed the incorrect and certainly misleading editorial note in the Supreme Court cases without taking the trouble of unconsciously apprising himself of the context in which Rasmi Rekha appears to hold Niranjan Singh's per enquirium, and equally importantly, to which provisions judgment an earlier judgment cannot possibly be seen as per enquirium as a later judgment, as the latter if numerically stronger than numerically stronger only then it would be overruled the former Rasmi Rekha. Rosif, what does it mean, Rosif? Just if the subsequent judgment, like there is Bihan Kumar's judgment, there are it comes numerically it's stronger. But here in our case, Rosif, Pankaj Bansal is numerically stronger because Pankaj Bansal has been supported by confirmed by the Ramkishore Arora. Thereafter, Prabir Purkaister, it has been numerically supported. But Bihan Kumar, there is nothing, Rosif. So if the subsequent judgment, sometimes it cannot be the meaning of what I have understood, Lordship, maybe wrong, Lordship. What I have understood, Lordship, that if subsequent judgment is numerically stronger, then it may not be treated as a per enquirium. But in our case, Bihan Kumar's judgment is numerically not stronger. It is lesser, Lordship. So this is the per enquirium judgment, Lordship. And there are some other one more issue regarding per enquirium, Lordship, that when the issue is sub-silent, that the judgment Lordship will find, Lordship. Lordship, thereafter, Lordship, my last ground is, Lordship, that if the judgment is the subsequent judgment is sub-silent, Lordship, the precedent which we are following, that is sub-silent. That is a judgment, Lordship, that is State of UP and another versus Synthetic and Chemicals Limited and another source.
Okay.
Here, Lordship will come to para 40, 41, 42. It says, Lordship, when any part of the judgment is the subsequent judgment do not touch that any part of the judgments and judgment has been given, that part cannot be treated as a precedent.
Yes.
Para 40, Lordship. Para 40. Inquiry literally means carelessness. In practice, per enquirium appears to mean per ignorance. English courts have developed this principle in relaxation of rule or state disease. The quotable in law is aided and ignored if is rendered in ignoration of a statute or other binding authority. Young versus Bristol Aeroplane Company Limited. Same has been accepted, approved, and adopted by this court while interpreting Article 141 of the Constitution, which embodies the doctrine of precedence as a matter of law. In Jayashiri Sahu versus Diwan Dubey, the court, while pointing out the procedure to be followed when conflicting decisions are placed before a bench, extracted a passage from Halsbury's Laws of England, incorporating one of the exceptions when the decision of an appellate court is not binding. 41. Does this principle extend and apply to the conclusion of law, which was neither raised nor preceded by any consideration? In other words, can such conclusions be considered as declaration of law? Hence, again, the English courts and jurists have carved out an exception to the rule of precedence. It has also been explained rule of sub silentio. A decision passes sub silentio in the technical sense that has come to be attached is not perceived by the court or present to its mind. Salmon on jurisprudence. The court did not feel bound to earlier decision.
Your point. Yes.
Lordship.
That it was not discussed.
Lordship. The main problem, Lordship, may come to para 42, the last part, Lordship. Reverse case, Lordship. Sale takes or purchase, Lordship. Sale takes or purchase. Second paragraph, third paragraph.
Another citation?
No, same.
In this case only.
Para 42,
Okay,
third
para
paragraph.
42.
That is
Okay,
it's
all
clear.
right. Yes.
Sale tax,
Yes, yes.
sales tax or purchase tax under entry 54 is levied on sales or purchase or goods. It does not contemplate any distinction between luxury and necessity. Luxurious are separately taxable under entry 62 part that has nothing to do with entry 54. What prompted this submission is not clear. Neither there was any occasion nor there is any constitutional inhibition or statutory restrictions under the legislative entry, nor does the taxation statute makes any distinction between luxurious and necessities for levying taxes. In any case, now it is important, in any case, the bench did not examine it, nor it base its conclusions on it. In absence of any discussion or any arguments, the order was founded on a mistake of fact and therefore it could not be held to be law declared. The bench further was not apprised of earlier constitution bench decision of waste, chemicals and state of versus state
It's
of
okay,
Bihar.
but you see, should I interpret all these laws?
Because Lordship, I'm saying Lordship
Because you see, in bail, why should I interpret the constitutional
because
laws?
Lordship, this is the retrospective and prospective issue has come, Lordship.
Okay.
If Lordship
Yes,
is
yes.
going to
Okay, okay.
discard that Bihan Kumar's judgment,
Yes,
why
yes.
it is not?
Now I got your point. Now I understand, yes.
And the Ganga,
To interpret the judgment.
why it is if it is sub-silent to Lordship, then it will be treated as it cannot be treated as a precedent, Lordship. That in all that is why I'm submitting, Lordship.
Okay.
Then when
In fact, it will strengthen your submission. It's okay.
then how when a judgment is parenquirium? If it is parenquirium, it cannot be a precedent, Lordship. And when that numerical strength is there, Lordship, that is also
All right.
all these judgments, Lordship says, Lordship, that Pankaj Bansal's judgment is holding the field, Lordship. Now, because if as it is holding the field, Lordship, and the subsequent judgment, even if comes, Lordship, on the strength same strength by the same strength of judgment judges, Lordship, then it will not be applied, Lordship. That is my humble submission, Lordship. And apart from that, Lordship, our own High Courts, 2 or 3 judges has also confirmed that issue, Lordship, that because as it is a Pankaj Kumar Bansal's after Pankaj Bansal's Lordship, in one case after Pankaj due to the after Pankaj Bansal that I have submitted, Lordship,
Yes,
Honorable
I got
Justice
it.
Mr. Mijul Kolita.
Yes, yes.
It is there is a paragraph 6 is there, Lordship, and it is stated, Lordship, as that case was rejected, Lordship. But even though it is observed, Lordship, that as the arrest is after Pankaj Bansal, that is why bail has been granted. And in one case, Honorable Mr. Justice Kaushik
Yes,
sir,
yes.
and that has also been rejected, Lordship. So my humble submission, Lordship, as there are all these 3 judgments has impliedly says that in extra that Pankaj Bansal's judgment is henceforth and it will go henceforth also.
Yes.
Yes, Lordship. Recent judgment, Lordship, on Ashish Katkar, Lordship got. This is after the Bihan Kumar and Pankaj Bansal. Lordship, it has been, Lordship,
Okay.
Yes, Lordship. Second page, middle. This being a clear non-compliance of the mandate under Section 50 of the Code, which has been introduced to the give effect to Article 22 of the Constitution of India 1950, we are inclined to set aside the impugned judgment, particularly in the light of judgment rendered by this court reported as Purbir Purkesta. It was affirmed the judgment of Purbir Purkesta. Otherwise, Lordship, Bihan Kumar is Lordship in clear judgment. It is the law of the land, Lordship, by virtue of Article 141 of the
Yes,
Constitution of India. It should be binding on all courts, Lordship. Once there is a established fact, there is a violation of Article 21, 22. It is the duty of court to uphold the fundamental right, the most precious right of
Yes,
the accused.
fundamental right.
Yes, Lordship, on that count.
At the
Lordship.
end of trial,
Yes.
transporting 8,000 drugs.
Lordship,
Tablets, fundamental right.
Lordship, otherwise, Lordship, being a lawyer, I
Not
must
fundamental.
appreciate this person will do again same thing. Lordship, I agree with the court. But what is the law, Lordship? But Supreme Court is very clear, Lordship. Once there is a violation, Lordship,
Right.
Lordship, not only in Assam, across the country, Lordship, this has been, Lordship, this practice
Fundamental
is going
rights have been granted to all of
on.
them.
Lordship, this practice is
Drug peddlers,
going on. Lordship.
murders.
Article 22(1) never says, Lordship, it
Lordship,
has to
Lordship,
be
one thing I would like to clarify my learned friend, Lordship. Even then, Lordship, after this honorable court, there is some direction in some orders to comply these requirements. Even then, Lordship, they are not, Lordship, complying.
They
Even
weren't
then.
complying. Now they are complying.
No,
Now
Lordship, in
made
some
forms,
occasion, Lordship, I have on
48
record.
form, 47 form. Now they
In
make
some
forms.
occasions, Lordship, recent, Lordship, last 13, one matter was, Lordship, heard in court number 19.
You must be happy when they're not complying.
No, yes, Lordship,
You
no,
must
I'm not
be-
worried, Lordship, I'm not on that.
When
But
they're not
Lordship,
complying, you must
no,
be
Lordship,
happy.
some of the person, they committed heinous crimes, Lordship. They are set free, Lordship, by the virtue, taking the advantage of that.
So
No, Lordship.
you must be happy.
No, Lordship, I'm not only being a human, Lordship, I have also some responsibility, Lordship.
So then why you are applying for his bail at the
No,
end of
Lordship,
trial?
but on law, Lordship. Lordship, they have to, Lordship.
Now you said you are being human. Now you said for the law. See, you're contradictory.
No, no, my contribution was law.
Don't worry.
We
don't
are,
worry.
Lordship.
Why are you so much worried
No, Lordship.
after his submission? You look so worried. I'll reserve this for order.
Yes.
And Article 22(1) level, Lordship, never says that it has to be retained in such manner as Bihan Kumar has said, Lordship.
No, Lordship.
Yes, or sometimes some law has been framed.
No.
Lordship, no,
It's
just
okay.
Lordship, for my satisfaction, your Lordship,
interpret
pick it.
according to
Lordship,
you.
your Lordship, check it later, Lordship. Just one point, Lordship. In Bihan Kumar judgment, paragraph number 15, Lordship, point number 15. Can you check it, Lordship?
Paragraph number 15.
15, Lordship.
Okay.
Paragraph number 15.
Only paragraph number 15. Others I won't check, no? I won't
Lordship,
check.
my learned friend also submit.
I am for item 43.
He also submitting that line. Paragraph number 15, Lordship.
I'll take up the submission together.
Sorry, my lord.
With him, I'll take up the submission.
No, madam. My
Continue.
submission is different.
Okay.
But Lordship,
My
one,
observation was that.
Lordship, one paragraph, then Lordship, I will conclude my submission. Paragraph number 15 of Bihan Kumar, Lordship.
Yes.
Yes,
You don't read that to me. I have read it so many times.
yes, Lordship, can you check it, Lordship? That's my humble submission.
এইটো এটা কাম কৰা, এইটো ইয়াত দি দিয়ে। ইয়াত এইটো বেলেগ এটা file এটা বনাই পেলাই দি দিয়ে।
It goes in favor of us, Lordship.
তাত তেওঁলোকে
Yes.
submission চবতে দিছেতো।
Paragraph 15 goes in favor of us, Lordship. I mark it, Lordship.
Okay, then Lordship.
I am for item 43.
Yeah.
Yes, my lord. I am seeking bail on two grounds. One is arrest procedure and another is
You divided.
item 43.
Arrest procedure.
Arrest procedure
That's grounds of arrest.
and another is, my lord, prolonged incarceration. There, my lord, I have been in custody since, my lord, 37/2023. Till date, my lord, no PW is examined. It is, my lord, 1 year, 9 months, 20 days.
1 year, 9 months.
20 days.
Okay. Not a single witness
Not,
examined?
not a single witness examined. In this regard, my lord, Dhirendra Kumar Chaudhary, Shariful Islam, and my lord, Nitish Adhikari is all in favor of me, my lord.
Okay. How many witnesses are in this?
Nine so are arraigned, my lord.
What is the contraband?
Contraband, my lord, this is only, my lord. This is 419 kgs of, my lord, ganja, my lord. It is ganja.
419 kgs of ganja.
Ganja.
Only?
Ganja.
419 kgs.
419
How can you
kgs
say
of ganja.
419 kgs only?
My lord, ganja, my lord. This is not tablets or heroin or something. Ganja, my lord, which is generally
Very healthy, no?
not healthy.
Ganja is very healthy.
And my lord, my humble submission in respect of my learned council submissions, my lord. In respect of retrospectivity or prospective effect, there is a law, my lord, when two judgments passed by the Honorable Supreme Court in a similar issue, the subsequent court should follow the latest one. And Pankaj Bansal and Prabir POCSO, in this regard, the Bihan Kumar is the latest.
And Bihans Kumar also substantiated by the Ashish Kakkar, my lord. And Bihans Kumar is very clear, my lord. Answered everything regarding Pankaj Bansal, regarding Prabir Purkasta, my lord. So, my lord, your lordship have gone through the Bihans Kumar. For a moment, my lord, I would like to place some paragraph. I would like to read, my lord.
Again, Vihan
Again,
Kumar.
my lord, because Bihans Kumar is very clear and Bihans Kumar answered everything in
Which
respect of
paragraph?
my line of submissions. Bihans
Which
Kumar.
paragraph?
Para, my lord, 14 and 15, my lord.
14 and 15. How
15.
many times
My
should I
lord,
read that
this is
paragraph?
right, my lord. Bihans Kumar specifically says that it is Article 22(1) and the constitutional mandate fundamental rights. Bihans Kumar is whole conceptualized the things regarding the fundamental rights, the Article 22(1). And it is at the conclusion part, there is specific directions. So once there is found, there is a grounds or not communicated, the person should be released on bail forthwith. So my lord, in this regard, even the Pankaj Bansal regarding para 15 is very clear. Supreme Court has conceptualized that. Pankaj Bansal, everything is mentioned.
Okay. It was transported in a truck.
In my case, ma'am, Ganja, my lord, yes.
Ganja, how you take it in a pocket? 419 kgs.
No, my lord.
Transported in a truck.
This is right, my lord. This I'm not saying that that I should be 100 million 20 days. I have been in almost 2 years, my lord, in custody for ganja. Whatever the ganja, sometimes, my lord, some people are taking. My humble submission, my lord, say even apart from this Bihans Kumar or Ashish Kakkar, I am also protected some other judgments, my lord, regarding prolonged incarceration. So my humble submission, my lord, in respect of retrospectivity and prospective effect, Bihans Kumar is very clear and Bihans Kumar should be followed. Everything is gone after Bihans Kumar.
See, just now he read and he was saying something opposite. He was saying something totally opposite to what he was saying.
His all answer is lies in Bihans Kumar, my lord. All answer lies in Bihans Kumar.
He was transporting ganja in the truck.
Truck, my lord. Not truck, my lord, exactly. I'm saying 12-wheeler truck, my lord, is right.
12-wheeler truck.
It is a daily routine checking stopped in 12-wheeler truck bearing registration number, so which was coming from Tripura towards Assam, was stopped in Nakai checking point and checked thoroughly, found special chamber and vehicle and suspected there may be concealed illegal items under the chamber. After breaking the chamber, my
Give me
plea
the
is that-
judgment, Vihan Kumar judgment, paragraph 14 and 15.
Yes, madam.
Yet I have given also. Vihan Kumar's judgment I have given.
My lord, I would like to proceed.
He has it.
Yes, madam.
Because I'll need it in other records, no? So I don't want to separate it.
No, I have also submitted.
He is giving it.
14, sir.
Give me the judgment.
Yes, madam. Bihans Kumar and Ashish Kakkar, madam.
Paragraph 14 and 15. Okay then. You have the LCR.
No, madam.
I haven't done.
In my
We
case,
need the
LCR is, yes. LCR is not received.
We'll need the
Not received,
LCR.
then receive the.
Huh?
If LCA is not received, proceed.
We'll need the LCR. I was about to pass an
On
order.
that day, it
but
was called for
because LCR, I cannot pass the order.
Otherwise, my lord, everything on record, my lord. That I
I
have.
was about to pass the order.
Regarding on
And
detail also.
was agreeing also.
My
But without the LCR, we'll need the LCR.
my lord, my lord.
This is motion.
Not motion, hearing.
LCA was called for on last occasion.
I'll
but it
last
is-
occasion call for not received, my lord. So, my lord, yes.
So if I'll be dead, then you can expect your order. You can expect an order. But if civil bench will be given to me, then no. Okay. We'll need the LCR.
Yes, madam. A specific short date may be given.
LCR as called for is not received. Call issue reminder to forward the scanned copies of the trial court records along with the scanned copies of the CD. List the matter
on third or fourth.
My lord, little earlier, my lord, have been in custody since.
Usually also it never comes. Also on last occasion also I paid for some more time and it was having a sorted. And
Maybe
it did not
because
come.
earlier, my lord, it is requisition already gone. Sometimes it may be on the way. So on 27 or 28, my lord.
How it will be on the way?
My lord, sometimes.
It's email.
On the 30th June, my lord. 30th May, my lord. 30th.
Did it?
Yep.
30th May. My obliged.
Maybe the lordship.
will not take more time, Lordship.
Please don't
Lordship,
take.
kindly may come to page
I'm
thir-
very
page
exhausted.
page
Since
34,
morning.
Lordship.
Uh,
Page 34, Lordship.
Page 34.
Yes, Lordship.
Co-accused released on bail.
This is the order, bail order of co-accused
Mm.
passed by your Lordship. And Lordship, kindly come to para 7, Lordship. Last part, the merits of the case are not brought to the fore as the trial is still in progress. It appears the bail was granted on prolonged incarceration, Lordship. So since the co-accused is allowed on bail, I also may be allowed to go without entering into the
Lordship, here also that issue was involved earlier, Lordship, that regarding notice issue, Lordship. If notice issue is he is not the council is not pressing, then we can go for the LCR, Lordship.
LCR is received.
But
Have you gone through the LCR?
that I have not gone through because today it was fixed for that issue of
Let him
notice.
take time. Let him go through the LCR.
1 or 2 days, Lordship, we
Okay.
will go through.
2 days time.
Okay, Lordship.
2 days time. Or
But
3.
on that day again, we will not argue on the same issue, Lordship, regarding 47 notice, Lordship. Because that
Don't
plea
argue
has,
in 47
that plea has also been taken by them, you know?
Plea has been taken.
He has also
Lordship.
taken.
Okay, it's up to you. Up to you. You decide between yourselves. Senate Council, Ms. Learned Additional PP, Mr. T.S. Locker has submitted for time to go through the LCR, which he has received today. Now, is the matter on Dudin Tindi?
Friday.
Friday?
Friday, no, 27. 27.
27? 27?
Monday के थे 26 and one Monday.
26.
On 27, Lordship, 26 time in a pay available.
Okay, 27.
27 go ahead.
Why others can submit?
Again, that this point raised,
Yeah,
Lordship,
okay, yes,
then again I have to submit.
27. I can 45.
Back to Lordship, my lord. I note
You are
that-
enrolled as an advocate now?
Yes, my lord.
In this
1696.
Okay. Because your brother's name is here. Yours
Yes,
is
yes,
not
yes,
here.
triple S Brahman. And I'm not taking lordships with valuable time, my lord.
Very good, very
For
good.
my land,
I
Please
I
don't
was
take.
submitted final.
Yes.
I was not able to go through the LCR, madam. This matter item 45.
le-
LCR received, my.
Give him some time. Give him some time. 2-3 days.
The last time, my lord, your lordship called for a scan copy.
Yes, yes, I've got it.
Yes, ma'am.
That is received.
Only, my lord, my bail petition was filed in the Honorable Special Judge at Monday 4 to 24 to 2025. And my bail petition was not considered, and subsequently only line passing in mechanical order, the bail was rejected.
Let him go to the
Only,
city.
my
He
lord,
didn't get time because they are overburdened with
your lordship is
because
also
of
tired.
new Jan Kumar's
Okay,
case.
my lord.
They are overburdened.
Yes, my lord,
now.
and since morning we have been hearing Vidhan and Pankaj, Vidhan and Pankaj.
yes,
Yes, yes. Can it be listed tomorrow, my lord?
Sir, why your name is not in the cause list?
My
If
lord?
you are enrolled as an advocate,
I have filed it, my lord.
I'll quote your brother's name.
My name should be there, miss, because I am.
You put the color number.
Yes, yes.
Learned Counsel, Mr. S.A. Rahman is present. Learned Edition.
Tomorrow it may be
Mr.
listed. Tomorrow, my lord.
Tomorrow, I don't think I won't be because tomorrow is a hearing date. Day after tomorrow, maybe. Day after tomorrow?
My lord, any day.
Learned Additional PP, Mr. K. Bose has submitted for time to go through the LCR which he has received today. List the matter on day after tomorrow.
My deeply obliged.
24.
May it please, Lordship, apology, Lordship, and call item call leg in court number 3, Lordship. Lordship, it's an anticipated bail.
In this matter, my lord, before my land colleague submitted, my lord, this matter was, my lord, looked after by Mr. Bhattakur, my lord. But because of some urgency, he has to leave, my lord. But he has before that, my lord, though I have not done through the CD, my lord. He has also pointed out one thing, my lord, that is in the time of the incident, my lord,